Okay. Aloha mai kako. My name is Don Cheng, and I am Chair of the Board of Land and Natural Resources. This is March 22nd, 2024, meeting of the board, and it is 9 o'clock. We are on time.
Thank you.
I'm going to just go over some public meeting protocols. We are holding this meeting as a hybrid. All of us are in person. No, all of us. Member Barnes has been excused today. But we are also holding this meeting remotely via Zoom, and it can be watched live on YouTube. For those here to testify via Zoom, we will let you into the meeting when the board hears the item you signed up to testify on. Please remember to mute your YouTube when you enter the Zoom meeting room, or we will get an echo. When you enter the Zoom room, please keep your camera off and microphone muted until the chair calls on you for public testimony. We ask that members of the public testifying on agenda items limit your testimony to 3 minutes, please. And so that we can get through everyone today. The chat box is not to be used for any comments because that presents a sunshine issue. People may also testify via telephone at the number posted online. Please let our board staff know your name and what agenda item you wish to testify on, so we can call on you for that item. You can also email your testimony to blnr@testimony@hawaii.gov. Before starting your testimony, please clearly state your name and identify yourself for the record. We may be taking breaks every so often. I'm now going to read the contested case statement. In some of the matters before the board, a person may wish to request a contested case hearing. If such a request is made before the board's decision, then the board will consider the request first before considering the merits of the item before it. A person who wants a contested case may also wait until the board decides the issue and then request a contested case after the decision, but before the close of the board meeting. It is up to you. Any request must also be made in writing within 10 calendar days. If no request for contested case is made, the board will make a decision. The department will treat the decision as final and proceed accordingly. In addition, the board may also go into executive session pursuant to section 92, subparagraph A, subparagraph 4, HRS, in order to consult with its attorney on questions and issues pertaining to the board's powers, duties, privileges, immunities, and liabilities. I am now going to take roll call of the board members. I will start with Riley Smith.
Aloha, Riley Smith, Hawaii Island Board Member. Morning.
Karen Ono, Kauai Board Member.
Norman Char, Oahu.
Don Chang, Chair of the Board.
Aloha, Kaiwi Yun, at large.
Doreen Canto, Maui Island Member.
And again, Board Member Amy Barnes has been excused for today. I'd also like to introduce our staff. I am so pleased to introduce Athena Iokepa. She is the board secretary, and we have technical support from Diana Lopera. And I'm also pleased to introduce our Deputy Attorney General, Joe McGinley. This is his first meeting before the board, so please be kind to him. His wife is also expecting, and he told her not to give birth until late afternoon. Yeah. I mean, literally, I think she's, yes. So he promised, and we promised that we would try to move things along. That's especially for me. So I'm going to go through our agenda items. We generally hear items in the order unless there has been a request for an item to be moved up. I am now going to read the order of the day. Items M1 to M10, which is DOT airports, is first on the agenda. Afterwards is HR 1, standing for harbors, 1 through 2, DOT harbors, they will be next. And then highways, RM2, and highways RM1 will be the next. After DOT will be Land Division D3, D1, and D2. After that will be DoCare, V1. Then DOBAR, J1, J2, J3. Following Dobar will be OCCL, K1, K2, K3, K4. And then finally on our agenda will be Division of Aquatic Resources, F1 and F2, which is a non-action item. Okay, I've gone through all of our preliminaries. I am now going to proceed with our agenda. Items M1 through M10 is that is DOT airports. We usually have, oh, there we got Daniel Oshiro. Where's Abby today? You can unmute yourself, Daniel.
Yeah, sorry, Abby is on vacation.
Oh, okay.
Well
Very good.
deserved.
Yes, indeed.
Okay, so I'm Daniel Shiro representing DOT Airports. Items number M1 through M10. Were there any questions or concerns regarding any of the items?
Thank you. Board members, do you have any questions on items M1 through M10?
Chair, no public testimony. I move to approve items M1 through M10.
Thank you.
Second.
Before we move on the motion, do I have any public testimony, either in the room or on Zoom? Seeing none, a motion has been moved and seconded to approve items M1 through M10. Since this is the first action to be taken by the board today, we'll do a roll call. Athena, if you could.
Chair Jang,
Aye.
Member Char,
Aye.
Member Kanto,
Aye.
Member Yoon,
Aye.
Member Ono,
Aye.
and Member Smith.
Oh my gosh, that's your first motion. Whoa, that's a big step. Okay.
We're running like a
I know,
well-oiled machine.
I know, I better not.
Don't jinx it
Yeah,
now.
don't jinx. Okay. Thank you very much, Daniel. We're gonna move on to items Harbor 1 and Harbor 2, HR 1, HR 2.
Hi, this is Derek Harn, DOT Harbors, here for both items, HAR1 and HAR2.
Very good. Thank you, Derek. Board members, do you have any questions on items M1, MHAR1, MHAR2?
Chair, no public testimony. Move to approve items MR 1 and 2.
Thank you. Are there any public testimony in the room? Any on Zoom? A motion has been made. Do I have a second?
Second.
Motion has been moved and second to approve items MHAR1, MHAR2. All in favor, please say aye.
Aye.
Any opposed? Motion passes unanimously with 6 votes.
Thank you.
Thank you very much, Derek. We're now going to move on to item. I'm moving so quickly.
You're not used to it.
I'm not used to. I mean, oh my God, it's only 9:09 and we're, oh, you know why I don't. My script is wrong.
MR1,
We're on
RM.
MR Highway RM. Did I say we were going to do 1 first? 2 first.
Two then.
Oh, no, I'm correct. Okay. M Highway R M2 and M Highway R M1. Okay, who do we have?
Hello, can everyone hear me?
Yes, we can.
Hi, yeah, this is Travis Tomono. I'm with the Highways Right-of-Way branch. I'm here to present for M Highway RM2. This was a previous submittal for the sale of two remnants on Molokai. At the previous land board meeting, there were a couple questions. One of them was to ask the owner what he plans to do with the property. Oh, I apologize. I'm also joined by right-of-way agent Jesse Hayashi. And in regards to the board wanting to ask the owner what his plans are for the property, I have in attendance via phone the owner of the abutting property, Mr. Gerald Anderson. and his lawyer, Gordon Stewart.
Okay.
So if the, Mr. Alderson, are you there?
Athena or Diana is,
We do have a number ending 4422.
okay.
Okay.
Is-
I have Gerald Anderson and Gordon Stewart calling into this. meeting.
Okay, we'll wait
Okay.
until they call in.
Oh, okay, I apologize.
No, no, no. I think we're moving the agenda much too quickly for them.
Yeah, I'm sorry to slow everything up.
No, I know, we've just got a rhythm going. But we'll wait.
Okay.
Do you have any,
Um,
while we wait, do you have any updates where you're gonna update us on at least what you heard, or you want them to go first? I mean, it's up to the chair, actually, it's not, but, yeah.
Yeah, I
think
mean, my
I-
understanding is that Mr. Alderson's plans are to build a single-family home at this time, but I think he can elaborate a little more.
And Travis,
Mr.
just to
Alderson, are you on?
reconfirm, the remnant parcel is approximately 4,700 feet.
Hold on one second. Yes, there are two remnant parcels. One of them, E6, REV1, is approximately 4,700 square feet. And there's another smaller parcel, remnant 22A, and that is 115 square feet.
And the property is, what is the property zoned?
It's zoned as interim.
I'm sorry, what was that?
Interim.
Interim.
My understanding is that basically it's sort of I'm not sure if this is the right way to describe it, but it basically has no true zoning.
So is a single family dwelling allowed on that zoning?
That I'm not sure. I'm not sure if we're just looking at the sale of the property, so that would be something that Mr. Alderson would need to clarify if he's
Okay,
submitted
I'll
anything to
ask
the
Mr.
county.
Alderson.
Right, right.
What is the fair market? The value will be based upon fair market value?
Hello?
Yes, yes.
Oh.
Hello?
Mr.
Hello, Mr.
Alderson?
No, that's Anderson.
Anderson.
Yes, this is Mr. Alderson. Can you hear me?
Alderson. Yes, we can, very, very clearly. Thank you, thank you. So, Mr. Alderson, my
Sorry,
name is.
whatever happened, I have heard the whole conversation.
Okay, very good, very good. So what are you proposing to do with the property?
If by the property you're talking about the remnants, nothing.
Yes. Oh, okay.
The remnants are tiny little slivers of property that are between a large parcel that I own and the highway. And not only do I have no plans to do anything with them other than to have the entirety of my property that is by the highway abut the highway. Nobody could do anything with them because they're too small to, they don't pass any zoning regulations.
All right.
So there's nothing that can be done with the remnants. I mean, this is simply when the main highway on Molokai was straightened, there were, so if you look at my property, there's a portion of it that abuts the highway, and then on both sides of that, there are, for probably maybe 20% of the property, the road was moved further away, and so there's these small slivers of land, which are remnants, which are just between my property and the highway. And there's absolutely nothing me or anybody else could do with those remnants in terms of building them or developing them.
All right, so Mr. Alderson, do you own both the lots, lot B1A and lot B?
Yes, I own both of them.
All right, thank you. Board members, do you have any questions for Mr. Alderson?
Just a concern.
So I'm trying to understand, so does this sliver of land that's being disposed of, resolved today, provide you access to the highway?
I have access to the highway.
Through this sliver or?
Right. No, through the top of my property where the highway is,
Yes.
there's roughly 50% of the property that goes all the way up to the highway. And then on both sides, we'll call them the shoulder of my property up near the highway. There's a thin sliver which remains owned by the state.
Yeah. My question is that sliver required for you? Do you access on to the highway on that sliver?
I don't think I understand there are no roads that cross those slivers.
It was formerly a road. It's no longer a road.
It was formerly a road, yes.
I guess back to the state, what will happen to the other slivers of property from on either side of this property today? Those slivers will continue with Department of Transportation?
Travis, that's more of a question probably for you.
Yeah, so you're referring to the remainders of the remnant after Mr. Alderson, assuming Mr. Alderson purchases it, the slivers of road on the sides of his property? That's what
Yes.
you're referring to? Yeah, they would remain with DOT. And just to kind of clarify, so yeah, it is an old remnant road. So technically, whoever abuts the road, whether it be Mr. Alderson or any other property, they have the right to cross over because it's classified as an old road. So technically it's.
Is there an alternative with these remnant parcels to convey it rather than lease or provide an easement?
I'm sorry,
Yeah, I mean, is there a possibility of just selling the property so that it no longer becomes a responsibility of the state?
Oh, yes, we're selling it to Mr. Alderson.
So is any steps being taken to sell these parcels, these slivers? As a remnant?
Oh, you mean the remaining portions to?
Well, even to
the
Mr.
opposite.
Alderson in this case.
I think that is the action. It is to sell.
But to sell?
Yeah, it's to sell.
Okay.
And as far as the neighboring parcels, we could ask, but we can't, we can't force them to purchase it.
I understand.
So Derek, on this map, I guess it was attached to the previous submittal. It says Kamehameha Fifth Highway, formerly East Molokai Road. Does that road still exist? I mean, that is the highway, right? It says Kamehameha the Fifth Highway. That is the highway, right?
Yes.
So when the state came in and widened the road, did Mr. Alderson have access to the highway? Or you have to drive through these remnant parcels?
He likely, has the right to drive over the remnant parcels because we consider it as an old road that used to be formerly, it was part of the old road. So it's classified as something in between a remnant and a road. So he has the right to drive over it, as do the other owners that abut the old road.
I think if I might, I might be able to identify the specific answer to the question that I think was being asked.
Yes, go ahead, Mr.
If you look historically, these remnants were part of the old road. If you take the old road in that area, part of the old road is now the new highway. And the other part of the old road are these remnants. So they're a long, skinny strip, which is the part of the old road which was not incorporated into the new road.
No. Yeah, for me, I'm just wondering, when DOT widened the road and they took portions of this old road, which abuts your property, and created this remnant, did they create a landlocked part? Your property is a landlocked parcel. So that the only way.
No, they did not.
Okay.
They did not.
All right.
Yeah, and I'll say this is very common on, especially on the outer islands. There's a lot of these on the Big Island where, there was a old road and we build a new road, but it bisects the old road. But even though it's technically like a remnant road, we allow, the abutting owners to access over the remnant, because otherwise we would have landlocked them.
All right. Okay, thank you very much. Board members, any other questions? Riley?
Go ahead.
Oh, Poole?
Just a thought, so Travis, so the zoning is interim, so there's a time frame in there, it's interim? But I say it's interim, I've never seen interim in zoning before. So how does that apply?
I'm sorry, go ahead.
So how does that apply, the fact that it's deemed interim? I've never seen this before.
Prior to this sale, I haven't seen that zoning either. I think for the most part that the zoning would only affect Mr. Alderson as far as what he wants to do with the property.
Okay.
And as I said in previous meetings, generally we don't get too involved with what the owner plans to do after the remnant is being sold. So we don't, the zoning is not really something we look at for remnant sales.
Okay, and then the submittal goes further to say that possibly in the future, there's a construction of a personal residence. Is this for Mr. Alderson? I'm looking at the submittal.
Well, are you asking me the question?
Yes, please.
Well, nothing can happen, and there will be nothing on the remnants. As to the parcel that I have owned for probably 20 years, that is zoned interim. And my understanding of that zoning is it allows you to build one personal residence on the property. And at the moment, I have no plans to do that. When this started 20 years ago, I did have a plan to do that. And I am now old enough that plan will not be pursued.
Thank you, sir.
Ryan?
Yeah, I just want to make a comment. A lot of times, I think when there are these remnant parcels, and if you look at the shape of it, you can kind of see it's non-buildable. But what it enables the adjoining property owner to do, should they own both, they can consolidate it to the property they own. And then it can, since there's typically an existing home, it allows them to have a bigger setback. It's really a non-buildable portion of land that enables them to add it to their parcel and increase the setback from the neighboring roadway.
Do they have to consolidate? Do they have to go through like a?
They don't have to.
Okay.
But if they did, I mean, you have two buildable lots, so you could consolidate this and create whatever the other lot is. You could create two lots and have a buildable lot. But he probably has that with the size of the lot that's there now.
Looks like a huge parcel.
Seems like this ag area, I think.
Yeah, okay.
So Riley, thank you. Let's say consolidation happens, it's in an interim zone, which I've never heard of either, but theoretically that could be a rezone, right?
Go through the zoning process, yeah, yeah.
For rezoning and then go whatever, R5, go build away, right? So, Mr. Alderson, I hear, excuse me, I hear that you don't have any plans for building. I'm a little bit more cautious about the next owner. I mean, and let me.
I can't speak for the next owner.
I know. I was just sharing my concern, and Travis, one of the questions that I had last time for you is, where's Molokai community on this?
Well, I
It's-
think
it's-
my answer would kind of be the same. It's not in our process for remnant sales like this to, have meetings with the community.
Okay, well, I'm gonna ask the same question though. I mean, so what I just laid out, and thank God, Member Smith kind of clarified this for us.
Mhm.
Because I guess you're not aware of the moving parts, but in the future, if it's consolidated or not, a new owner can rezone the interim zone to something else. And on Molokai and community in Molokai, that possibly could be an issue, I'm guessing.
Mhm.
Because land in Hawaii for Hawaiians and Molokaians is very important. Very important. Molokaians, did I just make that up? I just did. People, a Kanaka from Molokai. Okay, so I'm not,
Right.
I'm not challenging you. I'm just saying that there are a lot of unknowns, at least for me, to vote confidently on this matter. And for me, the community and their input is crucial.
I mean, what I would say is that, normally if they do change the zoning, that would go through the county. And that, I can't say exactly what the county, the permitting department's procedures are, but I would think that they would involve the community. And they would, look very seriously if they were, if the next owner were to build something like a hotel or something major like that. But, once, generally our sales are sold as is, and once it's sold, we cannot continue to be involved and monitor the property.
Yeah,
I mean, I understand your concerns, but it's sort of our procedures that have been in place for a while. I'm not sure if you're implying that maybe we shouldn't do remnant sales, but that's sort of how the remnant sales go. We sell it, and it could very well, another owner could sell it. I could sell it to another owner, and another owner tries to do something else.
Yeah,
At that point, it is out of our hands.
Yeah, Travis, I respect the process and the rules that you're governed by. It's just that, if you look in the past and these conveyances of land, I would say most often than I'd like, they turn into something that's problematic for the community. And should we have made the decision, a Pono decision at that time, perhaps we could have alleviated a lot of this community stress and land issues. So while I respect what you're saying, again, I cannot support something like this when there's so many unknowns dangling in the air.
Right?
Yeah, maybe I can just make a few comments. So typically what happens, and I see a lot of this on Hawaii Island. So you have an old roadway, and one in particular is like Mamalahoa Highway that connects Waimea to Waimea Kamuela to North Kona. And so you have a road, and the history is that maybe it was a cart path or horse trail. And so the radius and the typical road section is kind of dependent upon topography and things like that. Then over time, DOT will come in and do a highway improvement project, just like when they built H1 through Kaimiki and Kapahulu, and all of a sudden now you have all these little remnants. And it makes no sense for DOT if those remnants don't fit in their typical road section. So you want someone else to have them, otherwise DOT has to go and cut the grass and be responsible for it and all that. So selling remnants is something that happens all the time. You know, our meetings are publicly noticed. And we do have a lot of items, but you know, it's in the paper. As Travis said, the land is owned by the county as interim. So if anybody wanted to do anything, there would be another public process to go through to change the zoning. So there are multiple opportunities for the public if they wanted to weigh in and say, you know, I've got concerns. But I think the first thing for DOT is they want to kind of dispose of these remnants so they don't have all these irregular pieces of property that don't fit their typical road section. So I kind of agree with that. The other thing is that during the standard appraisal process, there are a number of different considerations that the appraiser will go through to value the property. And what they're supposed to do is consider the value of the property to Mr. Alderson, because it's probably of highest value to him because he owns a lot next to it. So if somebody else wanted to come in and buy a triangular sliver like that, you can't do anything with it, right? You don't own the adjacent property. You don't have utilities, water units and all that. So the appraisal is supposed to handle what the proper value is to the buyer. So I think maybe we don't have all the information, but I think there's enough constraints and there's enough future public processes that will protect the interests of the community, that if they have an issue, they're going to have plenty of opportunities to say, wait, I got a problem. Let's talk about this.
Riley, would you have a ballpark estimate as to if we were to add up all these remnants, say in the past 100 years that were conveyed, how much square feet are we talking about? No way of knowing?
Yeah.
Okay.
Any other questions? Board members, any other questions? Anybody in this room would like to provide comments to item H, Highway RM2? Seeing none?
I move approval of the recommendation by staff.
Second.
Motion has been moved and seconded. All in favor, please say aye.
Aye.
Any opposed?
Opposed.
Okay, so there's 5 votes in support and 1 opposition. Thank you, Mr. Alderson.
Thank
Travis,
you.
Thank you very much. Item
Thank you.
All right, I appreciate it. Thank you. Bye.
by Travis, are you also doing Highway RM1?
No, that would be my colleagues in our
Okay.
office. Thank you.
Thank you very much, Travis. Okay,
you.
Highways RM1?
Oh, yes. Good morning. I'm Kim Amahol with the Department of Transportation, the Railway Office, and requesting the authorization and approval of the Highway RM1, which will lead into Land Division D3.
Yes. So board members, any questions of Mr. Ho regarding Highway RM1? Anybody in the room here to testify? Oh, please come forward. Luke.
Good morning, Chair, members of the board. Luke Sarvis with Land Division. Been working with DOT and DAGS and formerly Public Safety on this for a while. We do need to request a technical amendment for this one.
The Highways RM1?
Yes.
Okay.
On page 2, the land title status, it's listed as Section 5B, Lands of the Hawaii Commission Act. So that should actually be corrected to acquired after 1959, non-ceded land.
Oh,
It's not ceded land, it's coming from the feds.
that's kind of a big deal.
It is, yes.
It's okay.
Luke, are these these federal undertakings? Is there a federal nexus of money or any interchange of that?
That'd be a question for public safety. I believe Wayne Takara is probably on here. I'm not sure how the new OCCC project is funded. There's a good chance it has some element of federal funding tied into it, but I've not been involved in that side.
And Chair, if you'd allow me, going back to number 2, would that also be a possible federal undertaking?
I'm sorry, so
No.
number 2.
Sorry.
Oh, you mean the highways to,
yeah,
the previous
okay.
action?
Yeah, says federal aid secondary project.
Oh, the highways were built with federal money in part, and that's why they're
So
called.
any future conveyance, my question is, does that trigger an undertaking?
I'm not sure what you mean by an undertaking. The nexus in this one is because there's a restriction to the deed for highway purposes, which needs to be resolved for correctional purposes instead. If there was a restriction on the deed to DOT, if the land is deeded to DOT from the feds for that one, then there may be a deed restriction, but I would assume that they would have.
Yeah, I don't think that I don't think it would be considered an undertaking,
Yeah.
there's no use of federal funds. It was previously, the highway was built with, probably with federal funds. That was clearly a federal undertaking, but I don't believe there's the sale, and I don't think any of the funds that we receive is going back to the federal government.
Yeah, and it wasn't, this one is because the feds owned the land previously. That's the nexus with the feds in this case. So it's different context.
Thank you.
Thank you, Luke, for that clarification. Board members, any other questions of either DOT or Luke? Is anybody in the room here to testify on item highways RM2? One, I'm sorry, RM1.
Okay.
Seeing no questions from either the comments from the board, from the audience, or on Zoom. Board members, do I have a motion?
So moved, Chair. As amended.
Okay, thank you. Okay, all in favor of the item highways RM1, please say aye.
Aye.
Any opposed? Thank you very much, Mr. Ho.
Thank you. Thank you.
Thank you. We've now completed the M items. We're going to move on to D3.
Morning, Chair, members of the board. Luke Cyrus with Land Division again. This is for item D3. So this is essentially the second part of the transaction. So when the new deed is issued with restrictions for correctional purposes instead of highway, once that deed is signed off by you, we will then set aside the lands to the Department of Corrections and Rehabilitation. And so I'm available for questions if you have any, but we don't really have a whole lot more to add there.
And Land Division, you have the trust status correct.
Yes.
Thank you. Board members, you have any questions for Luke? Members in the audience, is there anyone here to testify on item D3? Board members, do I have a motion?
Move approval of staff recommendation.
Motion has been moved and seconded. I will note for the record that member Yoon has stepped out. So all in favor of approving item D3, please say aye.
Aye.
Let the record reflect that there's been 5 votes yes. Thank you so much. Thank you very much.
Thank you.
Thank you.
Item D1. Good morning.
Good morning. Good morning, Chair.
Good morning.
I'm Michael Ferrer from the Land Division of DLNR. And this is for the set aside to the Department of Agriculture for agricultural purposes. It's kind of an ongoing thing, Act 90.
Yes.
Anybody have any questions?
Yeah, I wondered, states ag purposes, what is the current use? Is it pasture or crops or what?
Well, on these, there's general agricultural. There's a residence on the first one for Diegas. On Lind, it's currently a pasture. And the other 3 are all pasture spaces. And they're all zoned they're all agricultural.
Board members, any questions for Michael? Okay, is there anyone in the room here who to testify on item D1? I would just say for the record that DLNR has been in the process of working with Department of Ag on those parcels that we have mutual agreements to transfer. And these were some of those parcels that we had mutually agreed to. So this is part of the implementation of Act 90. to formally transfer those to the Department of Ag through a set aside for ag purposes.
Sure. Move to
Yes.
approve as submitted.
Okay. Anybody here? Nobody here to testify. Okay, a motion has been moved
Second.
and seconded to approve item D1. All in favor, please say aye. Let the record reflect that there's 5 votes. Thank you very much.
Thank you.
Thank you.
Item D2. Rebecca?
Yes, hi, good morning, Chair, and good morning, members of the board.
Morning.
So this item D2 today, this is a continuation of a prior matter that the board has considered. The board asked for some additional research and some additional information. And originally, the board considered this matter at its meeting on January 26th under agenda item D4. At that meeting, the board voted to approve agenda item D4 in part as amended and defer in part for 60 days. And this submittal is the 60-day follow-up that the board requested for some additional research. So the land disposition requested by the applicants in this matter is a 25-year term, non-exclusive easement for an area of filled land and a seawall abutting the applicant's private residential property. The seawall and the filled land were constructed by the Army Corps of Engineers in 1939, and they've been in place since. Research conducted by staff shows, at the direction of the board, shows that the requested disposition is compatible with both the land use policy that was been created by the board and the legislature for the Kaneohe Bay area, and it comports with the existing controlling statutes. In fact, the disposition requested by the applicant is a less intense land use and is subject to greater oversight than the majority of the land dispositions that currently exist in the Kaneohe Bay area. The majority of the existing shoreline land dispositions, including those for the properties that directly abut the subject property, were issued under or in conjunction with the Kaneohe Bay Amnesty Program, and they are for 55-year term exclusive use easements for piers and associated structures. We also saw around the time of the Kaneohe Bay Amnesty Program, we saw a lot of sales in fee simple of filled land that is similar to the filled land at issue today. And that includes one of the abutting properties to the subject property. In contrast, the present applicants are requesting a 25-year term, non-exclusive easement that will be subject to approval by the legislature and the governor. And it also will be valued differently than most of the existing land dispositions were, valued at a higher rate, in fact, based on appraisal of the fair market value of the land. The appraisal will be paid for by the applicant. And in contrast, most of the land dispositions issued under the amnesty program were valued at a lower than standard rate based on the tax assessed value of the abutting fast land. It is clear that based on the research that the land dispositions, as I said, land disposition at issue is compatible with current policy and current statutes. Also, abandonment of the current land management policy would result, or denial of, and also denial of this land disposition today, would result in a significant loss of income to the Beach Restoration Special Fund and a significant loss of income to the beneficiaries of the Public Land Trust. The land at issue is ceded land, and it is subject to the Public Land Trust. And in fact, when prior land dispositions in Kaneohe Bay have been considered, state agencies, including the Office of Hawaiian Affairs, have supported these types of land dispositions based largely on the income generation for Public Land Trust beneficiaries. You've got my submittal, and I'm willing to answer any specific questions that you might have.
Thank you very much, Rebecca. Vernon.
I believe I asked the questions previously, and thank you for all the background on Kaneohe Bay. Makes more sense. I'm wondering, however, especially since both of the side lots have otherwise been disposed of previously, by prior action of the board, whether something other than an non-exclusive easement would be appropriate in this case. In other words, a lease rather than a non-exclusive easement, because there really isn't any way to get on the property from either side of the adjacent lots. I'm also wondering the ramifications if with the proposed non-exclusive easement versus a lease or revocable permit, whether the real property tax will be assessed for this property, and whether under whatever provisions you put, the wall that is there will be the responsibility of the applicant, the homeowner, rather than the state, that we have no obligations to maintain the wall. What I'd like to see is, whether there's a consistent pattern, as apparently there was an effort in the past with adjacent properties and other portions of Kaneohe.
Maybe I can speak. Russell Tsuji, Administrator, Land Division. We've had this program of the amnesty program, and we have those applicants, and they were afforded the luxury of the statute and the legislature's mandate to issue those leases, exclusive leases for peers out there. However, notwithstanding the peers, that was for peers, Member Char. It's really a non-exclusive easement as to everything else, such as in this case for the remnant wall. I mean, not the remnant wall, but the wall, the seawall. Yes, every single encroachment onto public lands that may have a private wall, we consider as it's on state land, but the private wall still is owned by the abutting owner. So yes, we definitely have maintenance and insurance requirements on those, an indemnity requirement, and so on and so forth. If you're asking about to make it consistent with how some of the dispositions was done in Kaneohe Bay as to the reclaimed lands and the fee sale, I think it's allowed. The fee sale of reclaimed lands is allowed under the Reclaimed Land Statute, the Submerged Land 17153. However, the Land Division has recommended for over 20 years now, instead of a fee sale, to keep that as an easement and keep the lands ultimately at the end of the day will be retained in the public land trust. Again, it is allowed. So a board could decide to allow a fee sale. Our recommendation is to retain it into the public land trust, i.e. trust law. We have trust property, trust res. Disposition of sales has been kind of like not really the policy of the state. It's actually been the opposite, is to retain the lands, to make sure you retain the corpus of the trust, hopefully into perpetuity.
I can understand a non-exclusive easement for the piers, because that's in the waterway, but we're talking here.
Actually, it was the other way around. It's exclusive easement, yeah, for the piers, yeah.
Or anyhow, an easement as distinguished from a lease, or in this case, though, we're talking about filled land. There's no pier involved, and we have a stone wall. So under these proposed non-exclusive easement, could we convert that to a lease rather than a non-exclusive easement? It would still be in public trust.
It would be. You could under 17153,
and
we have not treated other similarly situated residents, whether in Kaneohe Bay or outside of Kaneohe Bay, for these reclaimed lands and shoreline. We've treated it as a non-exclusive easement term.
So in the other instances of leases or non-exclusive easement, whose responsibility is the stone wall?
Absolutely, the owner.
The owner. And then real property taxes are real
absolutely.
Property taxes?
We're not responsible for the taxes. It'll be the land. They may be taxed, I understand they are taxed, but that's really a county issue, as a county real property tax issue. We don't. get
Yeah,
involved.
I can point out that while we didn't have the time in the 60 days that the board requested for us to come back to review every lease in the area, we did in land division review many of the leases, and we think is a representative sample. And all of the leases, all of the contract documents, whether it's called a lease or an easement or anything else, all of these contract documents specify that repair, maintenance, insurance of any structures that are on the land are the responsibility of the private property owner. And also the documents also specify that the private property owner is responsible for any and all assessments, taxes on the land or fees associated with the land, whether that's assessed by state, county, fed, or any other government agency. So that we can confirm that the document terms do in fact clearly and directly place those responsibilities onto the private property owner.
So the applicant, in this case, the landowner, is accepting of the recommendation of a non-exclusive easement in this case?
That's correct. That's correct.
Okay.
Rebecca, can I ask you, so this additional, do you know how the county real property tax, is there a difference on whether it's an easement or a lease, whether that additional land is part of their real property tax assessed value? Do they, or is that, what does how does the county, do they even assess this additional land to the adjoining?
My understanding, and I'm not an expert on tax law or county real property tax. However, my understanding is that this land would be treated just like any other and would be subject to county assessments just like any other. And regardless of the name that we give the land disposition, that it will be treated exactly the same by the county for tax assessment purposes.
And treating the same, meaning that it would be considered attached, a part of the landowner's.
My understanding, yes, my understanding is that that is true.
I do want to also share with you, thank you very much. I think you took very seriously the board's recommendations and comments to do more research. I did find the additional, I think maybe 100 or so pages to be, I mean, it was very comprehensive. So I do want to acknowledge, Rebecca, the good work that you did on that. Thank you.
Thank you.
I am disappointed, Rebecca, you couldn't do all the leases within 60 days.
Well, you know, give me a few more hours in every day and maybe.
I share
We're all looking for that, right?
I share the chair's sentiment. Thank you so much,
Thank you.
Russell and Rebecca. Great job.
Thank you.
I just want to comment. I think I'm pretty familiar with real property tax on Hawaii Island.
Okay.
And I think typically what they do is, so the owner owns lot 32.
Yes.
So, and I think that's his residence because he was on Zoom the last time.
Right,
It looked
right,
like he
right.
was living there. And so if it's your residence, your primary residence, you have deductions, for age and everything like that if you're a homeowner. So on the property you own, you have all these deductions because of age, ownership, tax status, all that. The lease or the easement that adjoins it is a separate TMK. So you get a separate tax bill for that. And
Is it, but this is state land, so the state, is that?
state land is leased to a private individual, it's taxed.
It's taxed?
Yeah, if it's used
Is
for
it
public
lease,
purposes.
lease, or does it make a difference whether it's a lease or an easement?
I
you know?
think the rate changes if it's an easement or a
Lower
long-term
rate.
lease. The term maybe
Okay.
has a different rate.
Okay.
But you do get taxed on that. And if you remember when we were talking about this before, and if we looked at some of the maps, and if you looked at the big area of Kaneohe Bay and even down at Kahului and some of the other areas within the bay, you can envision how this area was before. It was coral flats, a lot of rainfall, a lot of sediment came down into the bay. And so people that had waterfront properties couldn't really gain access through boats and other recreational stuff because it was shallow. So then Rebecca put in all this information about how the Corps of Engineers came in and dredged out this area. And if you look at the Google Earth maps, you can see how all these frontage lots, they probably built a marina wall, an ocean wall. And then when they dredged it, they put the dredge material behind the wall. So it probably wasn't compacted. It probably isn't structurally suitable to build a house on it, but it created more land and they had to put that coral and sediment somewhere. So it was an opportunity to not have to haul all that off somewhere. And so they created more land, but the property that the homeowner could purchase is the original property line, but more land was created, that's state land because it's accreted, yeah. So I think there is a tax consequence. I think he is taxed on this. I believe it's at a lower rate. So the value per square foot is less because it's not structurally sound. You can't build on it. The term is shorter. So I think they're supposed to weigh that in when they do their annual assessment of the value of the property, which turns into taxes.
Are they responsible for submitting the easement documents to the county? Because right now the county just sees this as state-owned land.
Don't we record these?
We record that, Rebecca? Oh, I see.
So they'll have
Okay,
access
okay,
to the recorded document.
okay. Thank you for clarifying that. Thank you. Any more questions?
Just to clarify, we don't record the easement. The homeowner may do so if he chooses.
Yeah.
But we do provide information to the counties about our GLs and easements that we issue every year. Specifically for the tax purposes. Yeah.
But I think it's in the best interest of the owner to provide that document because it would be at a lower rate.
Or if they don't, there would be no rate. They wouldn't. How would they know?
Like I said, Chair, we report to the counties annually the land dispositions that we have for leases as well as easements.
Do you
specifically
know,
to the real property tax for real property taxes purposes? Yeah,
So
to the real property tax.
do you know whether they
The difference they charge? No, no, we don't get into how the difference between the easement and the real property. The lease, my guess is, I'm not sure if there's a discount like Board Member Smith says. We just, what they've asked us to do is just let them know for the leases and the easements that we issue. So we provide that information to them.
And Rebecca, the homeowner knows this is a non-exclusive easement?
Yes, that's correct. The homeowner does know. The homeowner is well aware. And I also think it's very important in this matter to point out that this action was actually initiated by the homeowner on his own initiative with no other reason. There's not been an enforcement action. He's not applying for any permits at this point. He's not applying for anything. The homeowner was merely aware that there is this unresolved encroachment issue and took the initiative and took it upon himself to approach Land Division to ask for this resolution. So the homeowner, I believe, is coming in. I'm confident the homeowner is coming into this with eyes wide open. And again, I think it's very notable that in this case, the homeowner took the initiative with no outside pressure and no direction from Land Division or the board to go ahead and resolve this issue because he realized there was an unresolved encroachment that needed to be taken care of at some point. And so he took it upon himself to resolve it.
Okay, thank you, Rebecca.
Thank
Board
you.
members, any other questions? Is there anybody in the audience or in the boardroom here to provide comment on D2? Okay, seeing none, commissioners, do you have any board members?
Move approval of the staff recommendation. I'm assuming the applicant is not present today. I'm here.
Oh,
Yes,
I'm
I'm
sorry.
here.
Oh, okay, Mr. Merriman, did you want to
Yes.
say anything? I'm sorry, we didn't,
Oh, start my video. Hold on.
okay. Thank
Hi
you.
there. I've
Oh,
been
there you
listening.
go.
Yes.
Okay.
Yeah, thank you very much. I've heard everything that was said and I agree with Rebecca.
Nice.
Yeah, I think all of this is pretty clear. And everything that was said is accurate as far as I know. To me, there's no ability to build in this area. It's just, I recognize that neighbors up and down the coast had the situation. And I was just trying to clean it up, unknowing what the process was, but I think I was treated really fairly and Rebecca's been great. And, I appreciate everybody considering this.
Thank you very much. Thank you for being here.
Okay.
Board members, you have
I
any
made the
questions?
motion to approve.
Second.
A motion has been moved and seconded to approve Item D2, all in favor? Aye. Let the record reflect we have Board Member Yoon back. Thank you. Okay, motion passes unanimously. So that is items we are, what do? We'll go on to B1.
Thank you.
Thank you. Thank you very much. Thank you, Mr. Merriman, for joining us today.
Thank you. Thank you.
Thank you, Land Division. Item B1. Oh my gosh, I don't think we have seen an item from DoCare. These have not come up before us. Nice to see you.
Good morning,
Good
Chair
morning.
Chang, board members. My name is Carlton Helm. I am a training lieutenant for the Division of Conservation and Resources Enforcement. So I'm here requesting to amend prior board action of May 13, 2022 to delegate authority to the chairperson to negotiate and sign facility use agreements and memorandum of agreements with DoCare Training Academy program partners. And the purpose of this amendment is to clarify that the board also delegates authority to the chairperson to procure and contract for goods and services necessary for DoCare Training Academies, including for lodging, equipment, and training materials.
Okay. Thank you very much, Carlton. Board members, do you have any questions? Yes.
So in the future, if you look at your, you have the submittal, yeah?
Yes, I
If
do.
you look at your Excel spreadsheets, the dark print on dark green, no can.
I can, she no can.
I know can.
Purple, I thought was
The
harder.
purple, the purple was
Yeah, I couldn't see
hard.
it, you know.
The red.
The purple was more
Okay with the
difficult
white.
than the dark green.
Green with the black. No.
You could.
Yeah, we can get that corrected in the future for,
Be kind to the kupuna.
yes.
Thank you.
Yes.
How many people do you have signed up for your next recruitment?
Right now, we're trying to fill 25 positions. Including that 25, we have 12 of those positions are focused with Marine Patrol. So want to provide some patrol efforts and in the oceans, the shorelines, which there's a lot of it. So this academy class is very unique where there's this ocean centric and want to make sure that we get employees specific to these areas that have been overlooked, and there's a lot of real estate to cover.
Land and water.
Yes.
How's that bill moving in the legislature about transferring DoCare?
From what I was advised that it was deferred.
It's different.
Yeah,
The
I'll-
transfer of DoCare is different.
Yes, it was. It was, yes. But that doesn't mean that it's dead. It just
Right.
meant that some of the committee members thought it was premature.
Mm.
But the department as a whole aggressively testified in opposition to the transfer. And we will continue to oppose the transfer.
So I only ask because let's just say whether we fortunately or unfortunately the transfer does happen, and does this affect anything? Would that affect this decision?
Unsure, but in my professional analysis, it would, because they already have an academy program themselves.
Yep, I agree. Okay.
However, we are very unique in what we do, and our training academy highlights that.
Yeah, I know. Okay, thank you.
And I don't know if Carlton mentioned, last year they graduated 41.
Yes.
And these were deployed statewide, and they really have made a difference. I mean, the DoCare officers have, their presence in our community has really helped us to fulfill our mission of preserving and protecting these resources. So I greatly appreciated your works. Thank you.
Chair?
Yes.
So can I make a comment? Could, Maui could use more enforcement.
It says right here in the purple.
I know. I can't see. Yeah, we meet, the land managers meet every month, and so that's always been a top story item, but we do need enforcement throughout Maui County. East to west, Mauka to Makai.
Yes.
We're working on it. I mean, I would say the legislature has been very supportive as well. So there is a pending request to release funds so that we can enter another recruit class. So, yeah.
We appreciate you folks. We
Thank
do.
you.
Really.
Thank you. I just want to make a couple comments. Since we hardly see you at our meetings, I want to take advantage of having your presence. And in a very positive way. So, I think the training that you guys did on your last recruit class, that was excellent.
Thank you.
For those of us that fly after our meetings and we're heading back to the islands we live on, took me aback. 4 very clean-cut, strong-looking men come up to me and say, "Hi, Mr. Smith, how are you doing today?" And I'm like, "Who are these people?" And they're like, "Oh, Mr. Smith, you're in our binder." So all of the board members, we have your pictures. We're required and we're tested on recognizing the people in public, being courteous and saying hello. And I even notice on weekends when I go down to the beach, I see some of the guys down at Wailea and they're looking for guys poaching or kayak tours that aren't regulated or following the rules. They come up to me, "Oh, good to see you in the ocean today." So very courteous, very polite. Handle. I think that you've trained them to reach out to the public, not
Yes.
wait to be approached.
Yes.
So I think that's really good for the youth to be role models for everybody else. Okay. The only other thing that I think that I've heard is that when all of the recruits were approved and then they were disseminated through the different islands that they work on, I don't think they had the infrastructure and equipment that they needed. And some of them, all of a sudden, had 12 more guys on Hawaii Island, but didn't have 12 more vehicles. So for them to be able to get out in the field and do the work that takes them out there, they were kind of lacking on some of that equipment. So I'm just saying, from my perspective on the board, I support what you guys are doing. If we can help to get you the equipment so that the guys that you train can get out there and do the work that you've trained them to, I wholeheartedly support that.
And I thank you for highlighting that, because that's the other component to the training, is having adequate equipment and PPEs, and to ensure, especially in places like Hawaii Island where their working environment changes.
Yeah.
Yes.
Yeah.
And I will share in response to your specific question about funding. Carlton was instrumental in getting and working with our congressional delegates to get additional funds for exactly that.
Yes.
Some equipment, some vessels, and some developing our maritime force. So we realize, yeah, it's not only bodies, but also the equipment to do the work. And so I think that is a real welcome, is that our ability to seek funds elsewhere to supplement and provide you guys the tools that you need.
Yeah, and the Academy program it's not just a training program and something that it's very unique to Hawaii, but it's also a catalyst for their very reason to go and try and solicit funds for equipment. So that was thought of in the plan as well. It just takes time.
Did you send a different crop to Hawaii Island? Because the guys that approached me, living out on the west side, like, "Oh, Katie, how's it, bro?" They want to see clean cut either, bro. These fuckers look like they're gonna beat me up.
Undercover.
Yes. We get the rough ones in here. Yeah, good job, you guys.
Yes. I think that what you're doing is fantastic. I think Dobar and Dar would be really thankful that now, you're gonna have the marine ability also. So I think that once that comes into place, that might actually correct some of our ocean issues that we've been having.
Yes.
Yeah, I appreciate that. And I mean,
Chair?
yeah, yes.
Before I forget. And so, since everybody's on a roll on this side, so I was at a fast food restaurant and 2 of your men approached me. Didn't call me auntie, but knew the face, So they said, "Oh, thank you so much for what you do." Da, 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 da. So I said, "Oh my God, you approached me. I should approach you." Very humble, very handsome and humble and gracious.
Again, different crop. That island, this island. Koi, you want to say something about the
I
handsome
did
guy on the
too. I
island?
seen them in Target parking lot.
Okay, all right.
And they did come up, 2 of them.
Brother,
We
it
see
might
how
just
we
be
work,
you.
Ma.
It
We
might
see
just
how
be
we
you.
work.
It might be you.
Thank you so much.
Thank you. So thank you very much. I think that, to to Board Member Ono's comment about the Marine Patrol, out of Doe Care comes Mackay Watch.
Yes.
And Mackay Watch is an instrumental, these are community members who get trained by Doe Care to supplement our community's ability to help us identify and support Doe Care's efforts. So Mackay Watch is a really instrumental program. And we're hoping to get Mackay Watches attached to each CBSFA.
Yes.
I know Kipo Hulu's reached out to you as well. So, you know, again, Doe Care is not just law enforcement. That's probably the last two that they use, but they're not afraid to use the hammer. We just got through reading about your efforts in Kaena with the film permits. But they have, and now we've got the Attorney General's office who is going to be prosecuting Doe Care cases because the prosecutor wouldn't. And I say this publicly because the prosecutor's office would not prosecute Doe Care's violations and citations, but the Attorney General's office will be. So I think we're empowering Doe Care with all the tools that they need to continue on their good work.
Yes, and I want to highlight that although we have intervention methods, our core fundamental is to really work with the community, have conversations with the community, and build that dialogue and trust. So that's a big part of what we indoctrinated at the academy.
Thank you very much, Carlton. Any other questions from the board members? Anybody in the room here to provide comments on item B1? All right, with that being said,
If no public testimony, move to approve.
Second.
motion has been moved and seconded to approve item B1. All in favor, please say aye.
Aye.
Any opposed? Motion passes unanimous. Thank you very much.
Thank you, board members.
You tell your chief you did an excellent job. Excellent job representing.
And I'll make sure we change the color.
I am gonna take as a move up, item K3. Laura Akua is here. She's formerly with DLNR, and she's here on item B, K3. So Trevor?
All right, good morning, board members. Trevor Fitzpatrick, staff planner with OCCL, presenting agenda item K3, which is Conservation District Use Application OA 3943 for the DOT Kaava Erosion Mitigation Project, which consists of constructing a approximately 400-foot linear length long rock revetment, which will be 22 feet wide. In 2020, it appears Kamehameha Highway was being threatened by erosion, and they placed some interim measures there. Those have failed, and they need to address potential safety concerns as the highway is continuing to be threatened by erosion. The application was published in the environmental notice on November 9th, seeking public comments. And additionally, on November 29th, 2023, a public hearing was held at Kaava Elementary School. Most, if not all, comments received were in support of the project. There are 3 special conditions that are included based on the comments received. And those are 23, no nighttime work. That requires outdoor lighting during seabird fledging season from September to December. 28, woody plants greater than 15 feet tall will not be disturbed during the bat pupping season, birthing and pupping season. And then number 29, the permittee or DOT shall inform Kaava Elementary School administration 1 week prior to construction so they can coordinate. The staff of Kaava Elementary and parents can coordinate around the construction activities. You have our report. We stand by it. I believe DOT and their representatives are here and they have a presentation. But staff, myself, and Kalmia Hara, who is our OCCL shoreline specialist, are here to answer any questions regarding this.
Thank you very much. Before bringing on the applicant, I noticed in the analysis, counties determine the project is not in the special management area. Is that correct?
Yeah, I would defer to DOT, but most of the project will occur either in the conservation district and Mackay of the shoreline. And generally speaking, areas Mackay of the shoreline are not in the SMA.
So measures that failed, you just mentioned, were they serious measures that failed or?
So you have on page exhibit 3, the photo of the sort of not engineered rock revetment and concrete cap. I think it was, I would defer to them and their engineers on what sort of.
What went wrong?
Yeah, but it essentially more wave action, more erosion sort of undermined these measures and they failed or are failing.
Are failing. Okay.
Sure, I have, I don't know if it's a question, a comment, or a concern. But, you know, we've been having a lot of residential homes that are falling into the ocean and we see no hardening of the surfaces. Yet here we are doing hardening of the surfaces for state highways. Is there alternatives to that?
So in the application, they did look at 4 alternatives: no action, highway relocation, protective beach, sand replenishment project potentially, and alternative revetment materials. There are probably alternatives that could be investigated further and may be possible. But again, we face a lot of difficult decisions ahead. In this case, this one fits the criteria in that there's a public purpose to it, protecting the highway that connects many of our windward communities on this side of the island. Whereas state law strictly prohibits private shoreline hardening devices.
Okay, nope. And one more concern. There's one of your items was notifying the school, condition number 29. Is there also something that maybe you guys could work with, like the tourism industry, so that there's less people going towards that side of the island while you're doing construction?
I mean, the board can amend the condition to include that, but I would also defer to DOT on
I
how
wouldn't
they
make
could
it a
coordinate.
condition, but, you know, to make some kind of announcement so that, because there's a lot of people on the road. So, I mean, there's more than just a school that needs to be notified.
Yeah, understood.
Just a comment. I don't know if you were here for Member Ono's comment about the purple text and everything like that. But in all seriousness, I think we should, and maybe this is for all divisions, it bothers me when we abbreviate Kamehameha in highway or school or whatever. So in the exhibits, you have concrete cap separating from cam highway shoulder. And that's just not yoked to kind of where I think the chair or DLNR is with Hawaiian values and Hawaiian culture. So just a note, if we can just spell our king's name out properly. Thank you.
Noted. Thank you.
Thank you for the comment. Seeing no other comments, I'm going to ask the applicant, Laura and DOT, if you'd like to come up.
Oh, is this how you got the move up? Inside job.
She's in the front of us now.
Yeah. Good to see you, Laura.
Good to see you, board members.
Thank you.
Aloha, Laura Ka'akua with Department of Transportation now. And with me, I have Gavin Chung from AECOM and David Smith from C Engineering.
Another David Smith.
Yes.
Wow.
We're all over the place.
It's causing confusion for sure. We do have a quick PowerPoint presentation, just really to show you all and any members of the public here or that might be watching online, some photos of the proposed revetment project. You can go to the next slide. We wanted to just show what actually looks like right now out on this coastline. We definitely hear Member Ono's comments about shoreline hardening not being the right long-term solution for really any of our islands. This is a midterm measure meant to address a really critical failing shoulder of the highway. So this is the way in and out for Ka'ava residents for multiple communities along the windward coast of our island. You can see here the road cracking and actually being undermined and at risk of caving in. If we can go to the next slide. Thank you. So in the shadows here, that's really just all open space. So you don't have the foundational, the structural support anymore. And this erosion will continue. And so the revetment project will preserve the road and prevent any safety issues, both in people actually being at risk and driving the road, but also safety just to have that dependable route in and out for these communities. We'll just go through the next slides fairly quickly. You can see here, high wash of the waves is sending sand over the highway. At this point, we have 2 feet between where people are driving and the high wash of the waves. Next slide. And so because this is the only way in and out for these communities, rather than driving all around the North Shore, it's a critical need that we have that safe, dependable access. This highway over here services 20,000 plus residents with 13,000 vehicles on the daily average. Next slide. So this is really our need for just to prevent the continued undermining, prevent any disruption to residents. This is not a large section. This is just the critical section that is caving in. And really our goal here, we realize this is temporary and that we need to do the long-term planning. We're supporting a bill going through the legislature. DLNR is also supporting this bill to do long-range planning for the whole coastline. And we're looking at federal funding sources for this too. So this is a priority area for us for that long-range planning. And I heard some ideas floating earlier on Maui. We're actually in the process of moving Honoapi'ilani Highway Mauka. So those long-term solutions, we will have to address them and make a lot of those hard decisions. This is just so that our community stays safe as while we do those long-term planning actions. Next slide. We know that this area has great cultural significance. And so it means a lot to the department to have support from Kealoha Domingo, who's the president of Ka'ava Community Association, as well as a descendant of the area. The Ka'ava Community Association knows and is supportive of doing the long-range planning with us, but they realize that we need something as a temporary solution now. With their feedback, we're also supportive of all of OCCL's conditions on the permit, including the need to have archaeological monitors for the duration of the project. Next slide. And this, I might defer to my colleague here to explain the design.
Sure. The upper left is showing another angle of the existing non-engineered shore protection that's there. When we talk about non-engineered, that means that rocks were placed in somewhat of a random manner, probably dumped. The lower left shows the cross
Can
section.
we zoom in on the lower left cross section, please? Thank you.
So the lower left shows what an engineered cross section of a revetment consists of. And starting at the bottom, one piece that's missing from the non-engineered is a geotextile membrane. So that's the dashed line with the curled ends. That's important through these sandy shorelines to keep additional sediment from leaking out through the rocks. Typically not done for non-engineered shore protection where it's simply rocks. If you place rocks, water can still wash through and keep eroding. So this is one of the components of the revetment that halts the erosion. The next layer beneath that is underlayer stone to help distribute the weight of armor stone. It's a smaller stone, in this case, 80 or 90 to 150 pounds, something kind of generally this size, with rock armor stone carefully placed to interlock and stay stable above. And those are 900 to 1,500 pound stones, and roughly kind of this big. It's about 2 feet. Stones are roughly 2 feet across. There's also a need to rebuild a bit of the shoulder. So to go into the dynamics of it, where the road is, and previously between the road and the shoreline, it was hard packed substrate. If you were to walk on it, it feels like you're walking on your lawn. When it's packed together like that, it has certain geotechnical properties that it can support substantial weight. As you know, when you go to the beach and you step off into the sand, boom, you're dropping into the sand, it's loose. In these areas where the erosion is occurring, we have beach dynamics, all the beaches, that sand comes and goes. The hard pack material is what we're concerned about. That's what's getting eroded. And that has eroded back close to the road. Even if the beach sand fills in, it has different characteristics. When there's a load on the road by car, a bus, whatnot, that gets transmitted underneath into the substrate below. There needs to be a certain distance and a certain competency of the substrate below to support the bus, the road, whatever the force is. The erosion now is underneath the road, which means there's potential for failure.
And David, I'm having a hard time reading the numbers. So Can you tell me what's the length? I'm assuming you're going to build this underneath this revetment. So what's the length that you're going out into the ocean?
Sure, and I can show you on another photo what that would look like. I can show that for you. So starting on the right side, we have the existing road, and then there's a 6-foot road shoulder.
Okay.
Next to that is a variable width, what's called grouted riprap pavement. So it's space. It's like CRM but flat.
Okay.
So it's stone and cement. When you get to the stones, three stone crest.
What's the width of that?
6 feet.
6 feet.
6 feet, 6 foot crest. And that helps with overtopping, energy dissipation of overtopping. The wider the crest, the more dissipation, the less water could go into the road. Then we're into the slope. 1 to 1 on 1.5 is typically what we use. That's the steepest that's allowed by or recommended by the Corps of Engineers Shore Protection Manual, it's like our building code for revetments. So that's the steepest for stable rock of that size. That's gonna go into the beach. So I'll show you on another photo. It'll come out and then it'll be buried. There's a larger dash line right where the hand is. That's typically the beach. And so it'll go into the beach, and then the toe of the revetment will be buried in the beach. Total width, I don't have it. I think Trevor said 24 feet, and that sounded about appropriate. 24 feet total.
Okay.
Do you want to show the picture?
Yeah, maybe we'll show.
6 and 12.
Okay, so what between the offset point and the edge of pavement where you have varies, is there no like a concrete wall behind where the It says wrap geotextile into under layer, see note 11. So I'm just trying to, so I guess the force is, it's being clawed out, right? The rocks are being clawed out from the shore, from the wave action.
Right, the sand is getting pulled out from underneath
okay.
and they're
So there's no lateral force coming in and compromising it this way as well.
Compromising.
Well, as the waves hit this wall, right, there's going to be impact to what's behind it.
The new one.
Toward the road.
The new one?
Yeah, the new one, right?
It'll absorb.
So
it'll
there's
absorb the
clawing
impact.
going out, and then when the waves hit, there's going to be impact to what's behind your 1,500-pound armor stone, right?
Right, but the revetment will take up those forces.
revetment will
The
take it
revetment
up?
will take up the forces.
Okay.
Right, so we've designed it in such a way, we're protecting the sediment from underneath and behind
Right.
from being exposed to forces. So it's being balanced. The revetment is balancing the forces behind it of the
Gotcha.
road and the substrate underneath.
Okay.
They're working together as a system.
Got you. So, okay, so the 900 to 15-pound armor stone, that's heavy enough to prevent the clawing.
Yeah, I guess if you're talking about in general, if we talk in terms of hydrodynamic forces, breaking wave forces for a 25-year lifespan, what we call a 25-year wave, yes.
Okay, and is that grouted or not grouted?
Not grouted.
Not grouted.
Not grouted. We don't want to grout it. We
Right.
want to have open for energy dissipation and limit reflection.
Yep, okay, and last question, where you show the dashed line of existing sand, right, like ground, typical. When it recedes, are the toe stones exposed at that point? If the sand recedes and all that?
They can be. They can be. The beach is dynamic, and we have pictures with a revetment or without. In fact, prior to the improvements that were shown on this page, the beach periodically deflates and rebuilds. So there's a likelihood that the toe will be exposed at some
So
time.
when the toe stones are exposed and the community's out there with the kids and everything, is that problematic?
I can't say if it's problematic or not.
Okay, thank you.
But it will extend, so from the highway, you're gonna extend from the edge of the highway, you have a shoulder, and you're gonna, what's gonna be the extension on, you're gonna create another, like a, I don't know what you call it. From, you have the roadway, then you have the shoulder, and are you also extending, I see the second, what is that?
Sure. but
Yeah, is that
it's
are you
like-
adding a total of like, was it 6 feet?
It's like a walkway.
Yeah, like, is that 6 feet?
6 feet will be from the white line on the pavement.
And that's currently not in existence because you're right at the shoulder,
It's
right?
eroded
You're right
back
at
to
the-
it in
So
most
you're gonna-
places.
So we're gonna extend another 6 feet that you, and then you're gonna build this revetment that goes in, you're gonna dig out the sand to place this revetment.
We're gonna take we'll take the rocks that are out there now.
Yeah.
They're sitting at a certain level up almost to grade of the road. Take those out, prep that area, and then dig on the slope, only as necessary, the slope down into the beach.
But almost, you're going out to 24 feet?
Yes.
Okay, well, let's see what your visual looks like and what this looks like.
Last question, David. Have you guys deployed this detail anywhere else on the island or any place?
Your community
Similar,
ones?
similar was built along Mauna Kea Road in Kauai. Kapa'a.
How's it doing?
What's that called? I think it's fine.
Okay.
It was a little bit different. It was a hybrid structure. There was a seawall there too. We have a picture of one that I designed that was built in Samoa. We've had several built in Samoa.
Maybe
Not that
try the
many.
next-
Not substantially different from Kaka'ako Park
Okay,
Uh,
okay.
in concept,
I
not
see, I
substantially
see.
different.
I see.
And this is perspective in general, what it would look like. So there would be beach above the water line intersecting with it. But it's a similar concept along the road.
This is a rendering of what it would look like?
This
or
is not a rendering.
This is actual.
This is one that I
actual-
designed
Oh,
that
I
was
see.
constructed in Pongo Pongo
Oh,
Harbor
okay, I was thinking
in American
Rendering,
Samoa.
that guy's talented, man.
Well, no, I'm thinking like, It doesn't look like the school across the street. Yeah.
That's the old Ka'ava.
I know, I said, okay, I missed that part, okay. And what's the length of this on the high, what's your?
It's
that you-
400 or 400 feet.
Okay, from Beach Park all the way down, how far, Laura? Past the school, front of the school?
From, I wonder if we have a slide.
To where the school is, from the beach park all the way to where the school is?
To about where the school is, there's an existing wall there today that we're gonna tie that.
Okay.
So there's existing shore protection to the south that we'll connect to.
Okay. All right. Is this your last slide?
I believe so. I think we, yeah.
And I am certain, knowing Laura, and that I'm certain you guys did community outreach.
Yes, we did.
And
We
the
did.
reception?
You know, I think it's, the sentiment is, no one loves this project, right? I mean, it's like, it's a necessary for the time being. And a lot of that community feedback too was, one, make sure we have archaeological monitors because of the culturally sensitive area. The other feedback is really for the department in general, like, hey, we should have been planning a long time ago. We need to really plan now for the long-term future, including those really hard possible decisions like moving the road. What are we gonna do with people who are right on the shoreline that take the road to the houses? So it's feedback on this in support, but also condition that we all know this is temporary and we need to do better for the long term.
I sat in all three of the meetings. It was a co-op meeting,
Yes.
We had 2 town halls.
Okay.
With the entire community
Okay.
from Hula to Kula.
Yeah.
The second is, we have a beach out
Yeah.
here, we have a
Right.
beach out here. However, this road is our lifeline.
Right, no,
This is the
get it.
work, the family, emergency services. Please, we need this road.
Yeah.
That's the bottom line.
Yeah,
And
and
it's-
Chea Aloha Domingo would have been here today, but he's in New York.
Oh,
So he wanted, I think there is a letter of support and he wanted to send along his support for the project.
Dave, where did you say the, you have?
One I designed is at Moanakai Road in Kapa'a. That went in about 10 years ago. They had a seawall and revetment there also, but they had some bad road undermining. And so we took care of that.
I mean, I grew up in this area. Well, I camped there and the beach was at least 100 yards out. I mean, we all remember fishing and going camping out there. There's nothing left. So I totally get it. I mean, I understand this is a critical connection for access. And can you reassure us that you have tried alternative models and this is the best model that you came up with?
Sure. We looked at beach nourishment. We regularly talked about beach nourishment with stabilizing groins in places. Those take time. They take a sand source. Sand sources are really difficult to find. And so, the Waikiki project, we started in 2016 and we're in year 9 on it. And so this is also time sensitive. So when we take all of that into account, that's,
And you've tried other kinds of structures. I mean, I will share 24 feet under, my fear is that is going to be exposed, or the beach, they're gonna lose beach permanent. What's the impact around the size of this project? The impacts to both, the west and the east side of the project?
Okay, so 2 things. If we can go back a little bit and you're talking about the size, one option to go smaller, unfortunately, is a vertical wall. You could build a vertical wall, retaining wall or seawall, whatever you want to call it, at the top, I don't know, 24-inch footprint, something like that, going back under the road. That's an option if you want small. The trade-off is reflection. And that's, we look at that. So when we design these, we're looking at where they sit on the profile, what all the wave dynamics are. When we have wave uprush and quick reflection, that tends to be what erodes the beach. It also happens when you have erosion of a well-packed earthen bank. You also have reflection off that that results in a flattening of the profile. So going with that, what else can we do? We're kind of limited because there isn't much in between. There isn't much in between a vertical wall and a lesser reflective structure like a revetment. And so this is minimized to the extent possible. I mean, we could, yeah, I'm not sure what else we could do.
We also, you might have heard, we talked about 25 years. We call this a midterm project. This is not meant to be the ultimate protection that would require a lot more discussion, a lot more planning. We chose 25 years because, as you mentioned, it used to be 50 yards, 100 yards wide. We've seen the erosion continue. We don't want to say, hey, we're gonna have something in place for 50 years and we all go away and ignore the problem. 25 years is a nice time frame. 10 years would be too short to come up with a solution. 25 is a nice number. It's in our minds. We need to get moving on a long-term plan. The rock revetment is something we can do now to save that road. Rock revetment, it's ungrouted. It can be removed depending on what that long-term solution happens to be. Whatever we decide, we can always remove it.
So I really appreciate that point. So if there is monitoring of this area and the project, so let's say in year 5, we're noticing the impacts that it's having on surrounding areas, we could reassess and say, okay, you've got to remove this because we're now threatening all the other properties around that or the beach that we may have to look at. I mean, I am assuming you're going to be looking at, if we approve this, and I'm not saying that we will or we won't, but if we approve this, that doesn't mean we're going to wait until year 24 to do a long-term solution.
did already.
Well, but I'm assuming this community too, Laura, they're going to hold you guys responsible. right?
Absolutely. Yeah, absolutely.
What's the cost per square foot?
Oh, I don't know square foot, but total cost.
We're looking at our
Sorry.
total cost between 4 and 5 million for construction.
1.5 million
That's not
divided
that
by.
bad as I thought. I thought it was going to be a lot more than that.
Yeah.
Isn't there
Okay.
a hike? Isn't there gonna be a hike soon on the cost of that? No?
Costs have been going up for several years.
Mm.
We normally speak in terms of linear foot rather than square foot, but it's still really just a rule of thumb.
Okay.
This one's about 10.
I could do
I think it's
that,
about
yeah.
10,000.
Okay.
But it's highly variable on the situation. Don't go forward with that because it depends on how difficult the construction is.
No, we're going to hold you to 4 to 5 million.
I'm assuming you're getting federal funds to this too? So you're doing a section 106 too? Okay. So, because I know that there've been EV kupuna that have unearthed around here. So I guess I would just urge that besides just an archaeological monitor, that there be a cultural monitor, someone from that community, because there are family members like
Kealoha.
Kealoha
Mhm.
and his Ohana. So I know that there are others, so it probably would be helpful to have a cultural monitor. as you're going
present
through.
as well.
Yeah.
Okay, thank you.
No,
We can do that.
okay. Board members, and Riley,
I just want to make a couple comments. Thank you very much for going in detail and explaining especially the public purpose of how this project is different from the others that we've recently discussed, including all of those at Kainui Beach, that Laniakea road realignment that we discussed 2 weeks ago. So it's important to understand that distinction of why we can be comfortable approving this one, whereas others we said no. Couple other comments. So, Mr. Smith, C Engineering, I've worked with the principals of your company for 30, 40 years, and you guys always bring really good designs that work. And the components of this design that I really like is one is the energy absorbing feature. So you don't get the refraction and everything that's going to lead to further erosion. And the geotextile membrane, I think that's so critical. There was a presentation for Kauai Small and Boat Harbor North. I think your company was involved in, but they didn't put the geotextile in there. And I think now they're going to do that. But it's so critical to keep the fines from migrating through the wall, which end up filling in the boat basin. So then the boat launch doesn't work. So excellent components that you're putting in there. Like you folks mentioned, this is a 25-year plan, okay? So the long-term solution is sort of what was done on Hawaii Island, where the road that goes along the island is not on the coast. So, you look at where Queen Kahumanu Highway is between Kauai High and North Kona. It's a half mile in, it's a mile in. So then what happens is you don't have tsunami issues, you don't have high surf issues. I lived in Hawaii Kai when there was a tsunami warning 40 years ago. And everybody waits until the tsunami is ready to come, and then they go on Kalanian-Ole Highway, and it was gridlock. And so parents couldn't get to the schools to pick up their kids. They're over there, half an hour to pick up my kids, and I'm gonna go Mauka. So the long-term solution is move the road, which Laura, you're saying that's the hard decision nobody wants to make now, but that is the solution that everybody's got to keep in mind. The sea level rise and everything like that, road's got to be in a different place, and so that is the long term. You got to move the road. So appreciate what you guys are doing, because if you don't do anything, it's going to get worse. And this is the key. Everybody that lives in Laie, Hauula, goes to town for work. This is the road they got to go on. So thank you very much.
And I understand there's also a pilot project that's being conducted by UH on artificial reefs. I think they're using Ka'ava but to build that is going to be a lot longer, and the scale of what would be required. So I do understand sort of the interim nature, but we have seen many interim projects that become permanent. So, but I do trust, Laura, that, your work, the community is going to hold you to this, to do that. And, Karen, your comment, and sort of Riley, your comment about, and appreciate the perspective. This is different. I mean, this is the lifeline, not only of Ka'ava, but everybody along that North Shore that has to drive through there. And when the roads are closed, they got to go all the way around. So I do get it.
And it's not only Oahu, it's not only Ka'ava. I mean, on Kauai, we have majority of our roads are on the ocean.
Yeah. No, I think so. DOT with Honoapi'ilani Highway, moving it up Mauka. I mean, I think that there are, and you're right, we're sort of catching up. But I do agree there is a distinction between a public project, a project that serves the public good, especially a major transportation thoroughway. And this is the only one. It's not like you have different access. I mean, this is it. So I do, and the fact that this community, I'm sure, was very difficult for them to have to accept something that will possibly impact their beach. So I too am,
I just have to bring that up.
No,
because,
that's very
I mean,
fair.
it's clear that we have canoe coming up
Oh, yeah,
today
no.
too.
Oh,
So
no, you should have seen I saw initial project that Ed Sniffen had shown me. I mean, these were like, it was going out to the ocean, these huge, almost like burrito, but it was more like a seawall that was being built up. And I'm like, that is never gonna pass. So I do appreciate the exhausting, all of the, the approaches. All right.
You guys secured the funding already?
Yes, for the project?
Yeah.
For this project? Yes.
Secured.
Going after the federal funds, we're asking for that, but if that doesn't come through.
Yeah. And then how long do you think your 106 is going to take?
We've submitted the determination letter, and it's in process for 30-day approval.
Yeah, I'm just worried about the timing as this thing is crumbling. And then if it's catastrophic failure, then the community cannot mobilize.
That 30-day period has already started, so
Okay, good.
we're at the tail end.
Oh, okay, good. All right. Good.
Chair?
Yes.
So this morning, we had an Uber driver from Ka'ava. So he did mention to Karen and I that he welcomes this project. And young gentleman.
Handsome young guy.
Handsome,
Married
in a
with 5
purple- in a
children.
purple car, yeah. He has 5 children, young, up and coming, so. Yeah, so he welcomes your project, thank you.
What an endorsement. There you go.
From
We've
Ka'ava.
had some really good drivers.
Okay, with that being said, thank you so much, Deirdre. Thank you, Laura.
Thank you.
Anybody else in the room here to provide a comment on K3? Anybody on Zoom? With that being said, do I have a motion?
I should move approval of K3.
The most silent person makes the motion. Thank you. He's listening, he's
I
been listening.
listen.
You listen, all right. A motion has been moved and seconded. All in favor of approving item K3, please say aye. Any
Aye.
opposition? Motion passes unanimously. Thank you very much, DOT. Appreciate you
luck,
being here
guys.
and answering the questions. I am going to take a break.
Bye,
We're
Laura.
gonna take a 10-minute break to 11 o'clock, and then I'm gonna go back to item J1.
Okay, fine. You live safe.
Thank you. We are back in session. Thank you. We are going to now move on to item J1.
Good morning, Chair and board members. Richard Howard for boating. Item J1 is the issuance of a right of entry permit to Pyro Spectaculars North, Inc. For proximity fireworks and stage effects display on Waikiki Beach on June 4th. Before I go any further, I need to amend the submittal. There was some miscommunication in our office. And so we need to amend the time of the permit. The submittal says from 8 p.m. to 9 p.m., but the actual permit will be from 10 a.m. to 10 p.m. The area in the submittal says 15,000 or 13,500 square feet. The actual area will be 910 square feet.
That's a big difference.
Yes, and the consideration for the permit in the submittal, it says 3,375 square or $3,375. Actual amount is $227.50. And it is. And one correction to make on page 2, in the remarks section, the last sentence of the remarks section, it says that all permits for the marine event are being procured under separate applications to DLNR, Dover's Oahu District Office, and the Department of Health. They do not, my understanding is they do not require Department of Health permit. So this fireworks show is going to have 2 parts. One part is aerial fireworks fired from a barge or 2 barges offshore, and that is being, the permit for that is through our Oahu District Office, Boating's Oahu District Office, and that is done under our Hawaii revised or administrative rules. Let me pass this out.
That's not part of this submittal, though.
No, but it is part of the show. And staff were also delegated the authority to issue permits, or ROEs rather. But in the interest of openness and just having the public be able to comment on this, we felt it was appropriate to bring it to the board. So they will not be shooting any aerial fireworks from the beach. Just want to make that clear.
That's not clear in the submittal.
Well,
I'm sorry, just for me.
okay, but I do want to clarify that. So there will be no aerial fireworks from the beach, but there are, and the applicant is here. You can ask him questions. He can clarify exactly what activity will take place in the right of entry area.
So is a legal reference for issuance of this 171.55 and 13.244.19?
That
Administrative rules?
It's administrative rules, correct. Well, the administrative rules covers the offshore barges. And I will gladly answer any questions, and the applicant is here to answer questions also.
I think, Richard, it might be really helpful. We generally hear these permits from the land division. So could you clarify why this particular request is coming in from DOBAR?
Well, the request is coming in from DOBAR because DOBAR is aware that fireworks are a sensitive issue with this board.
But jurisdictionally?
Jurisdictionally, the Waikiki, the beach, the Waikiki Beach is under jurisdiction, and that's where the ROE is being issued for.
Megan, can you, because we always get Hilton Hawaiian and and it's land division. So if you could clarify.
Sure. Megan Stats, I'm the assistant administrator for the Division of Boating and Ocean Recreation. So yes, I know land division does come in front of the board for fireworks permits or at the Hilton Hawaiian Village. The jurisdiction for the Division of Boating and Ocean Recreation starts at the walkway at the Hilton Pier. And the beach going from the Hilton Pier all the way down to the police substation is all under the jurisdiction of voting. And that's the reason why we're bringing this forth. And like Richard said, we do have the ability that we can issue a right of entry for a one-day event. But due to the concerns that we've seen in previous board meetings with the Land Division, because this was a fireworks display on Waikiki Beach, we wanted to bring it forth to get your input, your comments, as well as have the applicant here to provide any answers that you guys might have. So it's two-part, like Richard said, right? We have the right of entry for the beach. We also have the authority under the United States Coast Guard. We have an agreement with the United States Coast Guard, an MOU, and we issue marine event permits on state ocean waters for the United States Coast Guard. So this is twofold. You have the right of entry, and then we have a marine event permit that we would issue for the barge and the activity taking place in state ocean waters.
Has it always been like this?
Yes.
Always?
Yes.
Forever?
Yes, we haven't brought in front of the board in my years, we've never brought a fireworks display for one day in front of the board.
2017.
That was the last time?
We did in 2017.
Okay.
Because this is at
And that-
Halekulani, this is at Royal Hawaiian.
Royal Hawaiian.
Royal Hawaiian.
So part of it is on the Royal Hawaiian portion of the beach and part of it is on the boating state beach.
Part of it's on the beach. So Richard said they're firing from the barge and not on the beach.
Correct, and I think Mr. Dias can probably add a little bit more of what's happening on the beach section itself.
Okay.
Yeah.
The discrepancy in square feet, the 13,500, was that just a clerical error?
That was a miscommunication error between within our office. Yeah, property management, the person who's working on this property management didn't get the updated area.
Yeah. When I saw 13,000, I was like, holy smokes.
Selected the beach.
Nuclears are like, what's going on?
Is
All
that, is the 25 cents per square foot, is that consistent with what Land Division charges?
No, Land Division charges, my understanding is 10 cents.
So part of when we came to do right of entries in front of the board, when we asked for approval, we said we wanted to do 25 cents per square foot, and that's what the board had approved.
You should have gone to Hilton Hawaiian Village. I'm just probably not a good joke, but anyway.
Strike that last one.
Yeah, probably not a good joke. Oh, board members, you have any questions? I know the applicant is here as well.
One last one. How many barge shows do we do like this a year?
A year? Most of them are on Oahu. It could be anywhere. It's usually bigger holidays, so 4th of July, New Year's, and then there's special events that are happening at some of the hotels. I would say probably 5 or 6 a year.
All right.
Just depends. Yeah.
Okay, thank
And I'm sure when the applicant comes up, because the board scrutinizes the permits, like at Hilton, the cleanup and things. So it would be very helpful for us to understand the scope of the activity on the beach versus what's happening at the barge. Because those are the kinds of, again, I'm not too sure if you had an opportunity to look at some of the land board submittals regarding Hilton Hawaiian.
I
and the boards.
participated in that hearing as well.
Okay, very good.
If I can just add just one more thing, because you're talking about cleanup, and I know Karen, you had some concerns about that. So when we issue a marine event permit to anybody conducting a barge fireworks display, we do put standard language that it is the responsibility of the sponsor to ensure that all the debris is collected from the beach, from the ocean waters, and disposed of at a regulated disposal facility. And I think in the times that we have issued something, there has been one time out of the last 20 years that we've done it, that we had one complaint that there were some debris that was in the water. That was probably somewhere about 5 or 6 years ago. And we directed the sponsor to go back out and do a cleanup. And they have made that as part of their regular thing. And that's why we have that in here.
That wasn't us.
No, no, it was not. Yeah, so I just wanted to add that. Okay.
Thank you. Why don't you come on up?
Yes, ma'am.
This is, and I'm sorry, if you could introduce yourself, please.
My name is Pat Dias from Pyro Spectacular North Inc.
I've also brought along with me Miss Yumi Shibata, representing in Royal Cosmetics, Mr. Dave Kajihiro, who is the Safety and Security Director for the Royal Hawaiian Hotel, Mr. Akio Ueda, who is the producer of the event. On the video, we have Jason Kim, the manager of the Sheraton Waikiki. We have Stephanie Pasquale and Bruce Albrecht from Hawaii Explosives and Pyrotechnics also.
Nice to see both Bruce and Stephanie. We usually see you
Always
on the, yeah. All right, thank you.
Always
Please, go ahead.
Any questions that you have, I am here to answer with regard to the layout of how the event will be performed. We have two components, the water side and the land side. The water side is the aerial display shot from barges provided by Sea Engineering. The land side will have a stage that goes over the pink wall and a few feet past the chain. And that few feet past the chain, 70 feet wide, is the area of our ROE that we ask for. On the land, the fireworks that will be fired are close proximity stage fireworks, small items that would be suitable for indoor arena type fireworks, things that you would see at rock and roll concerts and that kind of thing, little stuff. And then a big part of the event, since this is Momozono-san is the owner of Royal Cosmetics. He does this event as an anniversary, the company's anniversary, to thank his best sales associates. And so 250 of the Royal Cosmetics people are coming. And so the fireworks term for what we place on the beach are called set pieces. And you've seen them before. It's a framework that have little tiny flares, and then when it's lit, it makes a picture. And it might be an American flag or something like that. In this case, on the left side, it says arigato. On the right side, it says Royal. And so those are the two big features.
I'm so sorry. I'm so sorry. I know. And it's a spam too. I apologize.
I silenced mine.
I should have silenced.
We all did.
Except for me. I apologize. I apologize.
So that's, and the question that I heard was, will there be any aerial fireworks deployed from the beach? And the answer to that is no. We will be far off the beach, and all of the aerial fireworks will be fired from barges. The largest caliber item that may be fired from the beach is 20 millimeters, maybe 38 millimeters at most, but most likely very small 20 millimeter comets and mines. With regard to the cleanup, which is very important because the Makai side affects the Mauka side. So fireworks, when they're fired, aerial fireworks, they have a paper shell, a rice paper shell. And when they explode, that rice paper shell turns into little paper chips. Everything else burns up in the air. And so the paper chips come down, and we call that fallout. So the fallout will go into the ocean. None will come onto the land unless, as in, I believe, last year's Honolulu Festival, there was an onshore breeze, and that caused some of the debris to be washed up. So we have a very specific set of best management practices that was part of our 100+ page submittal to DOBOR that outlines how we clean up. On the Mauka side, my wife and I are divers and have been divers for many, many years. So the morning after the display, we dive for a minimum of 4 hours, and we clean the ocean floor. We pick up any paper that has floated to the bottom, and we usually get quite a bit. of paper, but what we also pick up is regular garbage. We usually get about 4 times as much regular garbage as we get paper. So also our debris, it's rice paper, and it is very quickly dissolved by the ocean. It's rice paper and paste. And I can tell you from personal experience, after 24 hours to 48 hours, I'll go down there and I'll pick up a piece of paper and you can do like this with it. And it dissolves into invisible tiny fibers of rice fiber. So very, it's a natural product, rice fiber. So it is our goal always to leave the ocean floor cleaner after we leave than it was before we got there. On the land side, we have, in addition to Royal Cosmetics, a Japanese information technology company called Comtech is coming in to watch the show, and they're coming with 60 people. They have a large contingent of volunteers who have volunteered to comb the beach and the shoreline and clean anything that comes up on the shore, anything paper that washes ashore. That will also be verified by myself and my wife after we finish diving. Then we will come out in the afternoon and again comb the water line to make sure there is no debris left. On top of that, there are the beach boys out there. And the beach boys keep that beach absolutely spotless. So
What happens out at the barge?
out at the barge.
Yeah.
So out at the barge, they pull into position.
How far out?
How far out? We have two different locations. We have a calm water location that is about 800 feet offshore, and we have a rough water location, which we've had to use in the past. It's about 1,500 feet offshore. Hopefully, the Mother Nature will be kind to us, and we'll be able to be in closer. And we transmit a signal that synchronizes the firing computers out on the barges with the music soundtrack, so that when the beats of the music happen, the computer knows when to fire the shell, so that when it breaks in the air, it matches the beat of the music. So the show is choreographed to.
How do you deal with people who are out on the ocean, swimmers, surfers, people using the ocean?
Part of the Mo permit is that we are required to hire DoCare vessels who patrol the area and keep any boats away. We have the Kamehameha suite at the Royal Hawaiian, which is high and observes the whole area. So we observe where the boats are. We're in contact with DoCare and with Sea Engineering, and DoCare maintains our perimeter. And we have also on the land side, DoCare officers who assist with maintaining our safety perimeter around the fireworks and interacting with the public that are on the beach.
Are they special duty or are they paid by state? This is state time?
We
require them.
Okay.
That's part of the requirement for the
Yes.
right of entry as well as the marine event permit.
Yeah, so we hire
Okay.
DoCare officers for the land and DoCare vessels and captains for the water side. In addition, the production company hires Phoenix Security, which is an extremely professional security company to assist us with maintaining the perimeter and dealing with the public. And also, we have this year we have 6 people from Protectors of Paradise, who will be with us on the beach. That again they're very kind and helpful to the public. In
These from Waianae, Protectors of Paradise, is that the same? group?
I'm sorry, what was I'm a little
Are they
deaf.
from Waianae? I know of a Protectors of Paradise from Waianae. Okay.
Yes,
Micah Doan?
Stacy
Yeah,
and
Micah.
Micah Don.
Oh, okay.
Yes, yes.
helped us the last year as
I see, I see. They
they're-
help steward our Makua and Kaena Beach Park with state parks.
They're very kind,
Okay, okay.
very kind.
Okay.
So that's our plan. And as I said, we have a very comprehensive set of best management practices. At the end of the display, we do part of it is a report that is a debris collection report that we will provide to commercial property in a timely fashion, and report on how much debris we picked up and where we picked it up.
Do you also pick up offshore where your barges?
Well, if anything lands on the barges, then once they get back to, part of the best management practice is making sure there's mitigation that we do, and then there's cleanup. Because mitigation is very important, and that's doing things before the show that prevents extra debris from coming into the water. So, for example, our shells are fired electrically, which means they have a piece of wire that goes to an electric match that initiates for ease of understanding, the fuse for the shells. We do what we call a strain relief knot that secures the wire to the mortars or the racks that we are firing from. So none of the wires go into the air. And so none of the wires, if it doesn't go into the air, it doesn't go into the water. On the shells themselves, we take off any of the lowering ropes, the strings that you use to drop them in. There's no plastic on the shells. And we do everything we can do to reduce the amount of excess material that leaves the barges. Another part of the best management practices is immediately to sweep the barges and collect whatever debris lands on the barges so that the wind doesn't blow any of the debris into the ocean. So we developed these. I was part in San Francisco. We have the California Water Board that has part of the EPA that has very strict rules about what goes in the water. And I'm a recovering attorney, so I was recruited to help draft the best management practices for San Francisco Bay. And we've modeled our best management practices based on the very strict California rules. We've modeled our Hawaii best management practices on those, and in fact made them even more comprehensive. And Stephanie and Bruce can testify that we worked together with them to develop their best management practices for the Hilton Hawaiian Village. So for us, it is of paramount importance to be the least impactful as we possibly can, and to clean up in such a manner that there's less garbage after than there was before we came.
Thank you, Pat. Board members, you have any questions for Pat?
Yes.
Yes, go ahead.
So cleanup was a big one for most of us, so you
Yes, ma'am.
kind of elaborated on that. Do you have issues with drones?
So drones are an emerging technology. Our company does have a drone division. And drones, in my estimation, and from my experience with them, we were one of the pioneers in the drone industry. My co-producer, Matt Gilfillan, started working with Intel when drones were first conceived of and invented. So we've been following the drone path through its entire development. Drones have a lot of problems. Hawaii is not well suited for drones due to the proximity of the ocean and the changing winds. And what happens with drones is the more wind is that there is, the harder they have to work. And so a typical in calm winds, a typical drone show will last about 12 minutes. And when you've got winds going this way, that way, the drones have to push against to keep their little pixelated pictures clear. And so they end up running their batteries down very quickly.
My concern was, would it interfere with your barge production?
Oh, so you mean not drone shows, you mean people like taking pictures with
No,
drones?
Drones in general, you know, they fly all over Hawaii, and I'm thinking, would it interfere with your operation? of the
No, ma'am,
barge?
they don't. The only thing, I mean, I have seen video where people fly their drones actually into fireworks shows where the shells are breaking, and they're not gonna hurt the fireworks. The only thing that I see happening perhaps sometime is if a shell breaks too close to a drone, it's gonna be an X drone. And so it'll be more garbage for me to pick up when I go diving.
No, thank you for that, Chair. I just wanted to comment, you know, thank you folks for what you're doing, helping Hawaii's economy to expand. Thank you for that. And then to your partners, you know, we appreciate them. They've come for us many times, and I'm looking to support, you know, your mission, and I just want to personally say thank you. Arigato.
Oh, my God.
But Riley, go ahead.
Just a couple of questions. So,
Yes, sir.
maybe the first one is for Richard and Megan, but DOBOR does not make any effort to inspect the ocean or impacts or clean up or anything.
No, we do not. We don't have staff.
Okay, so, and I didn't think you guys did, so I just want to confirm that. So one thing is how well you perform under this permit, assuming it's approved, is going to be impacted about how you self-conduct your cleanup.
Yes, sir.
So we have a lot of people in Waikiki that are very concerned with cleanup after fireworks shows. So the success that you have with cleaning up after your work will make it more likely that a future permit might be approved. The counter to that is if you're not successful in doing that, and what will also impact your ability to get a future permit.
That
Because
is,
they don't check your work.
that is
right?
well understood.
So you gotta self-monitor.
Yes, sir. Yes, sir. And self-monitoring, and it's the same in San Francisco Bay, and they're way meaner than you guys are. And self-monitoring is 100% incorporated within our best management practices. And if DOBOR requests, I'll also take pictures while I'm down there diving to show how well we've cleaned. And
But what I'm letting you know is it's not gonna be them.
Right.
And it's not gonna be us, but it's gonna be possibly a former board member who's gonna go out.
I know I know who that's gonna be.
Gonna take pictures.
Yes,
and he's
sir.
gonna show us what you're not doing.
Yes.
So you need to be extra diligent in your cleanup, so we don't get negative feedback.
And I'll encourage Keone to do that.
Never named anyone.
Well,
The last question I had is, in the anchoring of the barges offshore,
yes, sir.
how do your barge operators know that they're anchoring in sand and not impacting coral?
Well, that's a very good question. And this is a question that I have discussed. We work with Andrew Rochelo at, he's our main liaison at Sea Engineering. And the anchors don't work when they land on coral. And Andrew knows where all the coral is and where all the reefs are. And so we have extensive discussions about barge placement. Sometimes we have to adjust the barges a little bit. And I'll say, Andrew, can you go a little bit north, a little bit south? And he'll say, well, if we go any further here, we're going to be either over rock or we're going to be over reef. And so they use sand anchors, and they typically they drop them the day before and then put a buoy. And so then they hook onto the anchor lines that are in the sand. And that is a very important consideration.
Okay.
So we don't destroy the reefs, and like I said, if the anchors land on the rocks, they don't work anyway. So,
Okay, well, whether they work or not.
Yeah.
If we get complaints later that coral was damaged, that would impact your ability to get a future permit.
absolutely.
Just make sure there's no impacts.
We are very mindful of that. Thank you for the question.
Board members, any other questions?
The barges, this is just staff that are on the barges?
Our staff?
Yeah.
Yes.
No public, no VIPs wanting to go out there?
Oh,
and
no.
see the fireworks? Okay.
No. We do what we do in the safest manner possible. We are trained professionals, and our people know what they're doing and know how to be safe. We don't allow the public, citizens, non-professional pyrotechnic people onto the barges. We know what to do if something goes wrong. They don't. And so it is only trained professional
No
pyrotechnic.
hoteliers or cosmetic people on the barges, right?
Nope,
Okay.
never happens.
I got it.
Well, and the other aspect of that is the barges are prepared and loaded in the Port of Honolulu. If you're just a regular citizen, you can't get in and out of the Port of Honolulu. Very strict. Mr. Pallone over there is very strict about who goes in, who goes out, and they watch from the tower.
Yeah.
So if somebody,
I just asked because the top salesman for the cosmetic company should not be on the barge.
Nope.
It's the ultimate arigato package.
if Momozono-san himself
Not
asked,
happening.
it's a no.
Okay.
And I'm one of the few guys that gets to say no to Momozono.
Okay. All right. Fair enough. Thank you
Yes,
very
sir.
much.
Thank you. Did you want to say anything? Did you want to add? Okay. Recovering attorney, I'm not really sure. I don't think you've lost all of your skills of conversation, should I say.
Well, thank you. Thank you very much. I don't practice law anymore. I was a litigation trial attorney, and now I'm I'm in the fireworks business full time.
Good for you.
So I went from the worst job in the world to the best job.
It's not that bad.
It's,
Speaking from someone who's on that side, it's not really that. But I thank you for your thoroughness,
Thank you.
your explanation that, yeah, so board members, so Megan, I'm assuming under do they have a separate DOBAR permit for the barge? Are you assessing them a fee for that as well? Yeah, come on now.
So that's a great question. Currently, the way that our rules are written, we do not charge for marine event permits. We are. But we have discussed this for many years, and part of our 256, chapter 256 package that we are working on, we're going to shift our marine event permits in there.
Okay.
And basically it's kind of what we've talked about is it's not necessarily a huge amount that we're doing because the impact is for a very short period of time, usually during a time in the evening, for example, when you don't have a lot of vessels that are really out there, anybody recreating during that time. But we are looking to do some sort of fees in regards for our marine event permits in the future.
Yeah, no, I mean, it does require us to process the permits. It does require us to monitor. So, I mean, I think that there's got to be some administrative costs associated with the perm. Plus, you're getting somewhat exclusive use of that particular area when your barge is out there.
Yes, ma'am.
So I'm assuming you also have insurance,
Oh,
a lot of insurance.
a lot of insurance.
Okay, that's going to be really helpful. I would also urge that there be, I don't know how you notify, but there are people who use the offshore, so whether it's, you know, you work with the beach boys or the hotels to put out some kind of notice to both their patrons as well as members of the public, even if you have to post a sign, offshore barge, firework project, you know, so that people know that there is, I mean, besides seeing the DoCare officers, and I'm assuming they're on jet skis, but besides seeing them circle around, you never know. I don't think we want to have a situation where we've got conflicting uses, someone who's surfing or swimming or transiting through that area. Because you're gonna be, are you closing this area where the barge is gonna be situated from 10 to 10?
No, no, absolutely not. The barges don't come out until about 4 hours before. They come out and they drop the anchors the day before typically. And then they come from the harbor and they end up getting in place around 5 o'clock is when I'm up there starting to
You say
place
they
them.
come the day before and they drop anchors?
They put anchors
Oh,
on the
okay.
bottom
Okay.
and then they put a buoy.
Yeah, okay.
So that
okay.
they can
So the
find it.
barge isn't coming in the day.
No,
before.
no, no. They use separate vessels from that.
Okay, okay.
And the Coast Guard does issue, they call it a non-permit letter,
Yes.
which basically just says, okay, you know, you're not going to be causing any undue hardship or impact on vessel navigation.
Okay.
And we do give a copy of our marine event permit to Sector Honolulu, and they also add that to their notice of mariners. So anybody that
Okay.
monitors that for vessels will be there. So
Because
that's
this is
also
going to
there.
be on a Saturday?
Saturday, June 4th.
Tuesday.
Oh, on a okay, Tuesday. Yeah, I happened to be down there in front, actually at the Royal Hawaiian, there were a lot of people in the water late in the afternoon. So if you are using a particular area, we would just urge you to provide notice to the public.
Yes, ma'am. And we have required safety exclusion zones dictated by the NFPA of 70 feet of clear offset per inch of caliber shell. So if we shoot a 10-inch shell, we've got to have a 700-foot radius safety
So
perimeter.
does that mean that you're going to close off that beach during?
No,
this
no, no,
event?
no, no, no. That's for the aerial shells. And so we'll be 1,000 feet offshore
Okay,
and have that safety exclusion zone patrolled by DoCare officers, and they're on boats typically.
Yeah, they're usually on boats, and they'll two-man crews for two vessels just to go around the safety zone during that particular time. And then, like we said, the requirement for the officers on land as well.
Right. And in addition to the DoCare boats, we also have support vessels that also patrol the water area.
so it's like board member Riley Smith said, if your actions this time, so if there are community complaints for whatever it may be, we'll hear about it.
Yes, ma'am.
Okay, so with
And
that
I-
being said, board members, any other questions? Do I have a motion? Motion to approve.
Second.
Okay, a motion has been moved and seconded to approve item J1. All in favor? As amended. As amended. Thank you for that, Mr. Richard Howard. I got a note here. All right. That said, the motion has been moved and seconded. All in favor, please say aye. Any opposed? Motion passes unanimously. Thank you very much. All right.
Mahalo to the board.
Thank you very much.
Should
Thank
note
you.
I abstained on voting on
Oh,
that.
I'm sorry. I'm so sorry. Let the record reflect that board member Ono abstained from that.
Char.
If you'd like to have a discussion separately afterward, I'll be happy to answer any other questions you have.
I'm sorry. Bertie. All right. So,
Thank you, Richard.
all right. So we're going to move on to item J2.
Thank you on behalf of the hotels.
Oh, thank you very much. Thank you. Take care. Okay.
Yes, sir. Thank you.
Okay, item J2 is, we're asking the board to authorize a 30-year extension to boating lease B99-1 to the Waikiki Yacht Club. And I will gladly answer any questions. Oh, yeah, something else.
Yes, you may.
Yeah. I know this has been an issue with the board as far as removal bonds. We
Yes,
did put that in the
Okay.
submittal that they need to obtain a removal bond, but it's not for the entire 30-year term.
Sure.
It's by the end of,
You have
yeah,
2034?
yeah.
Yeah, 2030. And I appreciate that you guys have put that in there.
Well, actually, I think we said removal bond by 2063.
2063.
I won't be here to verify that.
You never know.
That's true. Okay. Board members, do you have any questions for Mr. Howard? Do I have anybody in the room here to provide a comment on J2? Have any, I don't see anybody on Zoom.
Yeah, I guess I have I noticed that there was a $3 million capital improvement program. I'm unclear as to whether the applicant is providing that and going to own the photovoltaic, or whether that photovoltaic will belong to the, and here again, I'm confused as to who it is that's putting that capital improvements in.
I think
Is it a different entity?
as far as I know, they are doing it themselves. I have to, I cannot give you, I'm sorry.
Is the applicant present?
I don't see anybody.
They said they're gonna zoom in. I
Oh,
don't know
Okay.
if he did or not. But in our conversations with them, they did indicate that they would be making this outlay. So I'm assuming they will own the
Okay, because it,
system.
reviewing the materials, it was, I was somewhat concerned, or like, for instance, look at Exhibit B, Waikiki Yacht Club. There's a reference there to an SPE and tax credits and the developer, and so I wasn't sure whether that was Waikiki Yacht Club or whether they are subbing it out to another entity, and who will therefore own the photovoltaic construction. Waikiki Yacht Club. So I'm sorry, are they present?
I don't see them. Athena, there's no one from Waikiki yet. Do you want to?
Yeah, look at Exhibit B.
Yeah, I'm reading it.
And that is what raised my question on it.
Yeah,
The items will be owned by the developer.
right, who they don't define.
And then the PPA allows the customer Waikiki Yacht Club to receive state and low-cost electricity with no upfront cost, while enabling the owner of the system to take advantage of tax credits. So it was not clear to me whether the provider of the photovoltaic was going to continue owning the system and not Waikiki Yacht Club.
Right.
And if that were the case, then whether there was an adequate consideration for capital improvements by Waikiki Yacht Club itself, not the developer, to enable the extension for 10 more years, or how many more years?
30 years.
30 more years.
Yeah. I think.
In your mind, Vernon, does it matter?
I think it
It does
does.
matter
Because
because
the
I
bulk
think
of
the
the-
consideration
Yeah.
for granting the 30 years is the amortization
Yeah.
of the
Yeah.
improvements
Right.
to the facility
Do we deduct
and
that?
whether it will enhance the property.
I think maybe we
Value.
should withdraw it
Okay.
and get that straightened out before, and bring it back to the board once we get that straightened
Yeah,
out.
because they were supposed to be here and that's the reason that we thought that they were gonna do it. But due to the concerns and very, very valid concerns, I think that we need to be answered before we can.
Does it change our the lease rent? I mean, it sounds like, does it? Because like in land division, when they're putting improvements, we also let them we extend, but
Mhm.
sometimes we let them deduct.
We
the
would
cost of-
not.
Yeah, I
um,
don't, so I mean,
They have 10 years remaining on their lease.
okay,
Okay, and we're finalizing the appraisal to set the reopening rent for those final 10 years.
One other question that I had was on the providing or the manufacturing of electricity from the photovoltaic. Is that only for the benefit of the Yacht Harbor Club? Or will that electricity also be utilized by, other attendant?
Yeah, I believe with the agreement, I don't know if it feeds back into HECO's grid. But it is for their benefit.
One day.
Yeah.
Hi, folks. I'm joining late. I got kicked out. My name is Ron Gridley. I'm from the Yacht Club. I apologize for joining late. I got kicked out.
Okay.
Vernon, would you like to ask him a
Yeah,
question?
I'm wondering, looking at Exhibit B, Waikiki Yacht Club, it appears to me that the provider of the photovoltaic, which is a major part of the $3 million capital improvements, will be owned by the provider of that, and I'm not sure who it was, SPE, the developer.
Yes, sir. I'll try to answer as succinctly as possible. So in order to move forward, we asked a provider to provide a bid, and we will certainly go out and look for a second bid as well. The intent is to put the solar onto the facility for the benefit of the club to reduce overhead costs. But certainly anything that is excess, I believe, will be sold back to the state and whatever appropriate mechanism. I'm not fully qualified in that, but that's my understanding. Just trying to answer your question. So I don't know if that helped or not, but that's what I understand.
Who will own the system and who will bear the expense of creating that photovoltaic?
I believe as it stands right now, through investors, it'll take that I think it's a 20-year period for that purchase to be complete. So the cost of that to install will then be paid off on a loan. Does that make sense or answer your question, sir?
No, I'm sorry. So is it the Waikiki Yacht Club that's taking out the loan to pay for this installation of photovoltaic? Or is it a different entity and you're really permitting them to put it up and then provide services to you at a charge for the electricity that's generated?
Yeah, I'm not sure if I can answer that with 100% certainty, but because it's going to be on the property of Waikiki Yacht Club, the investors that will purchase that, will have to be reimbursed for that cost. So, in other words, I'm not sure if it's going to be under the name of the investor or the club, but it's my understanding that the club will be responsible for that purchase and then the repayment of the loan.
Who are the investors?
We're still working through that right now, sir. We don't have those investors by name yet. And it was really dependent upon the length of the loan and the extension, because for anything of that magnitude, it's going to require approval And it has to be for a loan, or excuse me, a period of 20 years, which is why we're asking for the extension to make sure that the investors and the banks will approve that loan. Does that make sense? Sorry.
Quite frankly, I don't understand. Coming back to Richard, though, is the 30-year extension predicated on the applicant, Waikiki Yacht Club, expending and improving the property to the extent of $3 million?
It is.
And if the answer is yes, then
I see.
I guess it's still unknown whether that portion attributed to the installation of the photovoltaic qualifies as the applicant undertaking that expense and going forward.
Understood.
I think under the circumstances, it may be, since Waikiki Yacht Club still is uncertain as to how they're going to do it, I would prefer to have a deferral and have the staff look at it to see whether it complies with the capital improvements in order to entitle them to the extension that's requested.
Thank you for explaining. Now I understand. Riley?
I'm not clear as the lessor why we would be concerned with a subcontractor making an improvement on leased property and regardless of whatever their arrangement is. It's like building improvements. If they get a loan, you don't check what the terms of the loan are for how they're building their vertical improvements. Personally, I don't care.
If there was a loan, then it seems to me that the applicant is the one that's putting in the funding. If, on the other hand, it's a private party that puts up the funding and provides the service, then the Waikiki Yacht Club is only promising to buy the electricity over a period of time. And I'm not sure whether that qualifies as a capital improvement by the applicant.
I'm not sure why I would care.
So if there's, just to clarify, what is Ron, Mr.
Ridley?
Yes, sir. Yeah.
Still there?
And
Okay.
I apologize. I'm calling from a hallway at work, so it's all kinds of. Anyways, thanks for your patience. Go ahead.
No problem. I'm gonna walk through it and you can just say yes or no to your current understanding. So without seeing the PPA, usually the PPAs are, you know, the third-party company installs, owns and operates the energy. And then you, as the customer, would purchase, purchases the system's electrical output. Is that correct? Is that your basic understanding?
Yes, if I understand the question, yes.
And the reason why you need the 20-year extension is because I'm gonna guess the third party needs to know that the yacht club is gonna be there for that duration in order to make the numbers work, right?
Yeah, yes, sir, that's correct.
Okay, so Vernon, I mean, to answer your question, no, the yacht club will not be in any ownership position once the PPA is executed. But they have to pay the third party to make up for that cost. So I don't think that the yacht club is going to the bank for a loan in its traditional sense.
If it were a bank and a loan, yes, I think it would qualify. But if the photovoltaic belongs to the provider, then it would not qualify.
Because 171.36 says the lessee. They have to finance okay. So I guess.
But in a way, they are financing it, just not through a
Well, but
traditional.
they pay electric regardless, right?
Yeah.
They're
But
just
that's
getting a
not gonna be
preferred
equivalent.
rate.
Yeah.
But
I don't know, I'm not.
how much are we requiring
I'm
them
not the
for
AG, so.
improvements?
Well, we're not they came to
So
us.
they want an
and
extension.
said, we want an extension, we're gonna make these improvements, and the amount of the improvements, our understanding was gonna be $3 million.
Right, and to answer your question, yeah, it's at about 3.5 now, and the issue is in order to be able to put the systems in, our current lease expires in 10 years, and that doesn't meet the requirement for the bank loan. So that's why, knowing that that the facility will still be leased by the club for that period of time, then that helps us acquire that loan. And I think the way the paperwork is written, we were hoping it would be explained there that, we have until the end of the original term of the lease, 10 years, to complete this project.
So normally for an extension under 17136, what do we require?
We require a dollar amount?
Yeah.
For
We
a,
just we require improvements.
yes. We don't have
We don't have a dollar amount.
benchmark dollar amount, but we ran into this on several occasions with different tenants. When Pacific Marine Partners came in and wanted a 10-year extension, they were willing to spend under 300,000. We said they wanted a 20-year extension. We said that is probably more appropriate for a 10-year extension. So we don't have a written benchmark.
Because we're really looking at how does it improve? Is it an improvement to our
Right,
property, right?
Right.
Well, then there's a life cycle cost of the
Yeah.
system itself.
Right.
It's not gonna be 30 years.
No.
No way. Not in Hawaii's climate, no way.
And its location. Okay, well, what's the board's, I hear, because Vernon, are you?
Yeah,
wanting a deferral?
I'm not satisfied. I would move to defer this until there's a further clarification on that portion of the application relating to the photovoltaic issue is resolved and we're advised.
I'm assuming the removal bond would also include those improvements as well, right?
Yes, yeah.
So it may change the cost of the bond.
For instance, if the photovoltaic company owns what they've installed, then it really doesn't enhance the property. If on the other hand, it was a traditional where the Waikiki Yacht Club went out and borrowed the money from the bank and gave a security interest, it's a little different on who owns the capital improvements and what security interest it has.
Well, I sort of hearing.
If I could, sorry.
The value of the solar, in 30 years, it's not going to have any value to us. So, it's valuable to the yacht club because it's going to reduce their cost, but it has no value versus the other improvements that we've received. It's like an improvements of the facility or upgrade, and we usually get the benefit for that. So,
So if I can help fill in the blank, I'm very sorry to interrupt. So just to try to amplify, in order to be able to put the panels up, it's going to require infrastructure improvements on the roof throughout. And I would say that certainly does benefit the state for the age of the building. That's going to have to be part of the overall improvement. And I guess the other part that I would just like to reinforce is no matter who owns the panels, no one's going to want to, for lack of a better term, touch or back that with the known fact that the lease is going to expire in 10 years. So that's really kind of the two part to help fill in the blank. I'm not trying to rush any decision by the members of the board, but that's kind of the situation that we're in. So without the lease extension, it's virtually impossible to secure a loan. The club is doing well, and we hope we are good stewards of the community. But to try to get any sort of capital improvement like that is going to be difficult without the lease extension. So
Yes, sir.
I
Thank
don't
you
know if that helped or not.
No, it does, and I was gonna bring this up. So there are some Trident to Pure CIP items listed under their Exhibit C, the roofing, carpentry, electrical service upgrade. Because I was gonna follow up with Richard and ask, did we receive these quotes or who did, you know?
The guy Clip provided us.
Okay, so we've seen the numbers. So these are real numbers.
I haven't seen actual quotes from contractors,
Yeah.
if that's what you're asking, no.
Okay. Well, when you come back, if we do defer, I'd like to see, I'd like just to, that you've seen it.
Okay.
And this is not, you know, Johnny come lately with a hammer and did the roofing and carpentry, right? You
Yeah,
know,
no, we actually have a full package that includes, like, no kidding, bona fide, certified, licensed, and not me with a hammer from Lowe's, folks, so, or
Yeah.
Home Depot, or whatever else.
Yeah, okay.
So
all
the
right.
improvements to the building is about $1 million. And it's it's the PV system is the 2.6. Okay,
Yes, ma'am.
okay, thank you for that explanation.
Yeah, you're welcome.
Riley?
Maybe if I can just add something. So Member Barnes is in here,
Yeah.
but if she was here, and she and I don't always see eye to eye, but I think she would say, since she typically says she has concerns with fossil fuels, I think she would say in this instance, you need to support photovoltaic that relies on non-fossil fuels because it's going to benefit us and our kids. So I did a photovoltaic project when I worked at Parker Ranch.
Yeah.
So I didn't own the improvements. First Wine Bank Leasing owned the improvements. They took the tax credits. I got cheap electricity. So I didn't own it. Thing is still operating. It's providing low-cost electricity to Parker Ranch so they can get water to their cattle. So I think this is Department of Land and Natural Resources that we should try to conserve our resources. I'm not sure what additional information the yacht club might provide in 2 weeks or a month or whenever they come back. But I would try to find a way to support alternative energy projects like this.
Thank you, Member Barnes.
And Mr. Ridley,
Yes, ma'am.
do you know what the life of the photovoltaic, based upon what they've disclosed to you?
Yeah, I can offer my opinion, certainly not a professional solar guy, but I think over the life of this thing, it's what you'll find in most locations around the island, up on top of the larger stores, to get these facilities off of the grid. I'm guessing an 18 to 20 year life cycle is reasonable, but I'm absolutely pulling it out of my tail. But I think that's what has been discussed throughout this, and I would just thank the board member or representative who offered getting any large location off of the grid and go to a more natural and green providing system would certainly be encouraged, and that's what we're trying to do as well.
Well, there was no second to my motion to defer, so why don't you make a motion to adopt, Riley, if you wish to do so, and
You know,
No, I.
isn't it a
Valid.
walkthrough thing? I mean,
Yeah.
I'd want to bring
Yeah,
down
yeah.
you guys. I mean, tell us how you feel. I mean, waiting a week, 2 weeks, 4 weeks, I don't think it's going to make a difference. I just want to be clear, if we defer this, that it's clear to the applicant what information you're expecting.
Well, I mean, I think you do make a good point on behalf of Board Member Barnes, and I think we are trying to encourage more photovoltaic. I just want to make sure that the life of the PV, as stated by Mr. Ridley, is going to be less than the term of the extended lease. So they're going to be responsible to removing that, because it won't be worth anything at the end of the lease.
Let me make a comment on that. Okay, so in a typical photovoltaic array, you got a lot of conduits, you got support structures. They want to have it face south, right, where the sun, we're in the northern hemisphere. So all the racking and everything is going to survive 30 years.
Even next to the
Photovoltaic,
shoreline, even next to Ala Moana?
they're made out of aluminum. They'll be fine. So it's the panels
Okay.
that degrade over time.
Okay.
So maybe it's 2% a year, 3% a year. So after 20, 30 years, they don't produce as much. But then you replace the panels, you put new panels. You have an inverter. The inverter takes the direct current and converts to AC so you can go into the grid. You take out that inverter, you put in a new inverter. all the conduits, all the racking, all that stuff is still viable. So maybe out of this total 3 million costs, maybe 2 million is in the electronics and the panels. So that has to get redone. But all the other conduits, racking, supports, photovoltaic panels on a roof are also an added layer of insulation. So I don't think Waikiki Yacht Club is air conditioned, but it cools the building. So there's other benefits besides generating electricity that improve the life of the asset. So, I mean, I think there's a bunch of things there, but, I'm fine with deferring, but just make sure we clarify to the applicant what we want from them, because I'm unsure what they would provide that we don't have.
Yeah, I guess what I'm looking at is pursuant to the application Exhibit B, I'd like to see what the PPA is and how it operates. I'm all for photovoltaic, generated electricity. But I am also interested in seeing what that power purchase agreement is, because it talks about a separate entity and the confusion in my mind as to who owns the system.
Yeah, my suspicion, it's like a community, what do they call that? HECO has a community where they use, for example, they'll use nonprofits, like, and then somebody else uses that, they put that, and they find investors but it's owned not by the landowner, it's owned by a separate system. But it does increase, it gives people who don't otherwise have an opportunity to invest in solar to get some kind of benefit. So, okay, do we have
Chair,
a
I'll
motion?
second for discussion.
Okay.
Yep.
Wait, is there a motion?
Yeah, he made a motion to defer.
No, I think he said he didn't get it. Oh, to defer.
Yeah, Bernie, didn't you make a motion?
I made a motion to defer.
Right.
Okay.
So I'll second for
Okay,
the sake
for
of discussion.
all right.
Move this along. If there's any discussion.
I thought that's what we were, I thought that's what
If
we
there's
were
no
doing.
discussion,
I thought that's what we were doing. So
Then you can take a vote.
oh, okay,
Yeah.
okay. All in favor, a motion has been made and seconded to defer item J2 for, and I guess Board Member Char has identified specifically some additional information that he's requesting. And I guess we would be timely resubmitting back to the board once we get that information. So all in favor of that of that motion, please say aye. Okay. Okay. 1, 2, 3, 4. All opposed? Okay, 2. I think there's a total of 6. So I think 4, 2. Yes, so I think 4 is quorum to pass the motion.
Okay.
Okay. Thank you.
Okay.
All right. So Mr. Ridley, you have some homework?
Yeah,
And-
can we be, I understand the vote, and I certainly appreciate that as a member of a board myself. I would just ask to be very specific for what you're looking for, because I'm not sure, like the information that we still need to provide. At the next meeting, maybe we'll determine exactly what difference that makes, but I got it. If you could just be very specific, I mean, I probably have that information, and we should have had somebody there in person today to be able to provide that. And the letter we received, anyway. So yeah, we can certainly do that. If you can help
Sure,
me.
we're
with
not
exactly what you need,
necessarily
we can
saying
do
we
that.
oppose it, but I think Mr. Richard Howard has the information, and I know but Mr. Howard.
Sorry, Richard.
Richard. Or Howard, whichever. It doesn't matter.
I'm so embarrassed.
No, I think
But-
I think I
okay,
have
you
the
got it.
items. I mean, it's
Okay, all right.
clarify the ownership of the PV
Right.
system.
And then
Board
also-
member Yoon wants to see actual,
Just that you've
or
seen.
that
it.
I've seen it,
And subsequently also regarding
PPA.
depending how it comes in, the policy of your division as to what constitutes a capital improvement if it's done by somebody else.
Sure.
I mean, it may still be that you feel it qualifies, but I think it forces you to think about these extensions and what the consideration is.
Okay, and also we have to nail down the life of the system. We want to see the power, the PPA.
Who owns the system?
Right,
And what security is provided?
right.
So that if the extended lease were defaulted on, would we then, the state then own the photovoltaic system?
Right.
And we-
Or would we be liable to continue the purchase, the power purchase?
Yeah, because I think the whole idea of capital improvements and extension is the ability of the state to benefit in the event of a default.
Okay.
And I wanted, so that's crystal clear, the board also notes and acknowledges that the roofing, carpentry, electrical services upgrade totaling $739,448 with its contingency is indeed capital improvement. Yes. I just want that on there.
Okay, with that,
Item J3,
J3, yes.
authorize a 10-year extension.
Thanks for your folks' time. Mr. Gridley's gonna, this is Ron, I'm gonna check out. Thanks.
Thank you very much.
Boating lease, H7014 to Cahey Marine. And again, this is an older lease from the 70s. It doesn't include at the moment any kind of participation in sublease rents. We will require that for the extension as well as a removal bond or whatever improvements. There's a lot of testimony in favor of this because this is practically only shipyard of its kind. So I think it's a good, and this would place the lease at 65 years at the end of the 10-year extension. Okay, good.
So do we have the board members, do you have any questions for Dobar?
The applicant's here to answer any questions also.
And the applicants, is that Mr. Morioka?
Yes.
And Mr. Cam? Did you want to add anything more to
Cam's the attorney.
okay, Mr. Morioka, do you want to add anything to the presentation? Oh, you're on mute. I'm sorry.
Okay,
There you go.
can you hear me now?
Yes, we can.
Oh, good afternoon, Chair Chang and board members and Richard. Just here to answer any questions you may have.
Okay. Field pipes for the field up. Any question, Riley?
No, I just had a question for Mr. Moroka. So, somebody I know keeps a boat at your harbor there.
Yes.
And he provided some very positive testimony about what you guys did after the Japanese earthquake that created a tsunami and the amount of capital improvements that you folks put in order to get your operations up and running again, and the amount of effort you put to put in state-of-the-art equipment. So
Yes.
I just wanted to give you an opportunity to tell us what you guys did and how much it cost.
So when the tsunami hit us, it pretty much destroyed the whole marina. It just got washed away. So we had to rebuild from scratch. Of course, the insurance paid for a lot of it, but we put in additional improvements in addition to what the insurance covered. So we hired Blue Water Marine to design the most modern marina facility at the time. That was about 12 years ago. So that's pretty much what we did.
Well, I think you're being modest, but what I was informed was that the marina was operational within a very short period of time. That you were able to provide services to your customers so that they could be in operation again. And I think one of the things we struggle with is making sure that lessees of state property maintain and improve their businesses, their capital improvements, so that the lands that we lease continue to be valuable because of the capital improvements you put in. And my friend that has a boat in your marina was extremely impressed and thankful for everything you guys did to extend the life of the asset and to improve the quality of these state lands. So I just wanted to make sure I got that on the record, that he was just glowing about everything you guys did, so that he didn't have to go moor his boat down in Eva, down at the Deep Draft Harbor, wherever the other
Right.
marina. He was very thankful for everything you guys did, so.
Yeah, we knew that there's a shortage of marina slips in the state, so we did our best to expedite everything so that we can get up and running as soon as possible. And it was about a year and a half, 2 years to reopen our marina.
All right, thank you. I just want to get that on the record.
And Mr. Moroka,
Yes,
with this extension, it does include the state's participation in sublease.
yes,
So does that mean, so it says board action dated,
Oh,
that's when we,
that's when the board approved Dobor's sublease rent policy.
okay, okay.
And the form is the same
Okay,
form
so
that
now
land
this is
division
effective
uses.
going forward.
Yes.
No, okay, I was wondering, it's not going back to 2021, it's moving forward, okay. All right. Any other questions? I know we did receive a lot of written testimony and support. Mr. Cam, did you want to add anything?
No, thank you, Chair. I'm just here to answer any questions that may arise. I don't have anything to add at this time.
Thank you very much. Is there anybody else on Zoom? Okay.
Chair, move to approve staff recommendation as submitted.
Second.
Okay. A motion has been moved and seconded to approve staff's recommendation for item J3. All in favor, please say aye.
Aye.
Any opposed? Motion passes unanimously. It is
Thank you.
now, thank you very much. It is now 12.
Thank you, members.
thank you, members.
We're going to take a lunch break. Okay, so we're going to come back at 1 o'clock. Okay, thank you, and I appreciate your patience.
Wait, is ready for lose or match this?
Which one? Very much. All right, thank you very much. We are back in session. It's 1 o'clock. We're going to move on to item K1. Trevor?
Good afternoon, board members. Trevor Fitzpatrick, staff planner with OCCL, here to present agenda item K1. And that's the appointment and selection of a hearing officer to conduct all hearings for contested case 2403 regarding Conservation District Enforcement File OA 1908 and 2107. If you remember, on January 12, 2024, the board found the landowner Zungo LLC and Mr. Newman in violation for alleged permit non-compliance, construction of an unauthorized shoreline control device, and encroachment upon state land. At the meeting, they made a oral request for a contested case. They followed up that with a written petition for a contested case in a timely manner. And as such, we're requesting or recommending that the board find Zungo LLC and its managing member, Mr. Human, are entitled to a contested case, that the board rescind its previous decision in the matter, so that any decision in order coming from the contested case isn't tainted, and that no government or person other than the department and the alleged violators will be admitted, and that the board authorize the appointment of a hearing officer to conduct the contested case and to delegate that authority for the selection of the hearing officer to the chairperson. Stand by our report, here to answer questions regarding the matter.
Thank
And I
you very
believe Mr. Robinson's here too, if on behalf.
Very good. Thank you. Thank you, Trevor. Anybody have any questions for Trevor? Mr. Robinson, did you want to add anything to the submittal?
Nothing to add, Chair. Thank you.
Board members, you have a motion?
Move to approve the staff recommendation.
Second.
Okay, a motion has been moved and seconded. We're in discussion. Any discussion? Seeing none, all in favor of the motion, please say aye.
Aye.
Any opposed? Motion passes unanimously. Thank you. Let's move on to item K2.
So K2, similar appointment for the selection of a hearing officer and to rescind the board's previous decision in enforcement file OA 2118 for contested case OA 2404. Same thing on January 12, 2024, the board found Sunset Oasis and members William and Melinda Kernot in violation. At the hearing, the alleged violators requested made an oral request, and they followed up that with a petition in a timely manner. Same recommendations as the previous one, and we stand on our report and are here for any questions. Again, Mr. Robinson's here if you have any for the members of Sunset Oasis.
Thank you very much, Trevor. Any questions for staff? Mr. Robinson, do you have anything you want to add?
Nothing to add, Chair. Thank you.
I will urge the department to move very timely on these requests for contested case hearings and the appointment of a hearing officer, and likewise, I know it will be up to the hearing officer to set a schedule, but we've got numerous contested cases pending, so thank you for your presentation. Board members, do I have a motion?
I have a move to approve.
Second.
Motion has been, oh, I'm sorry.
Any testimony?
Oh. No, okay, thank you. Motion has been moved and seconded. We're in discussion. All in favor of the motion, please say aye.
Aye.
Any opposed? Motion passes unanimously. Thank you very much, Trevor. So, item K3.
Oh, we did K3 already,
I'm
sorry.
Okay. Oh, we are on item K4, that's right.
Yeah.
So, if you could just announce I have an announcement, so if you could just call the item.
Sure. Agenda item K4 is regarding amendments to Conservation District Enforcement Case OA 2154 regarding noncompliance with the Board of Land and Natural Resources findings in Conservation District Enforcement Case OA 0550 located in Pololo Valley. Do you want me to?
Nope, that's it. So, board members, for the record, I'm going to recuse myself from this matter. Mr. Anderson's family filed a quiet title and partition action against my mother's family, the Ho'okanos, for 4 landlocked Kuleana parcels in Kahalu'u, which resulted in a 25-year litigation. So due to the appearance of a conflict of interest, I'm going to recuse myself from this matter and ask Board Member Yoon to preside over the matter. Thank you.
Chair, anything else to add to your? Well, let's wait for Chair to leave.
Not that I would officially, no, I have nothing else to add.
Okay.
Thank
Okay. I just want to make a disclosure. So the applicant petitioner on this, I work with his grandson, but I have no business interests or anything that he's doing. I just wanted to disclose that, but I don't feel that's a conflict for me to be involved.
Okay, thank you, Member Smith. Anything else to add?
We stand by our report and its recommendations. If you guys have any questions, I'm here to answer that, as well as staff planner Tiger Mills.
Okay, board members, any questions for staff? Okay, does the applicant want to say anything?
Mr. Anderson is here.
Yeah, I know. I'm looking, and do you want to say anything? You want to come up? No?
She has counsel.
Oh, I'm sorry. You're behind this red shirt.
And then you want to come on? Good afternoon, acting chair, members of the board. For the record, my name is Eric Robinson. Have not recovered, still an attorney here today. So in your staff, I'm sorry, in the testimony packets, I understand there may have been some issues printing the exhibits that I had included with my testimony. I've provided some hard copies of those in color. I've also got some enlarged photos here, should the board like that, as well as PowerPoint that has the imagery here. So what I wanted to kind of cover today is that this has been a long ongoing issue that started back in the 80s when this property was owned by the Bond family. They constructed picnic shelters in a storage shed, and the storage shed is what we've got at issue today. So this parcel is quite large, as you can see in Exhibit 1 to my testimony. So that's this one here. That's a steep hillside, and historically, the way that section of the property has been accessed was from the uphill portion. So at the time these were built, the uphill lot where these were accessed from was owned by the Bonds family, who also owned the subject parcel in this enforcement action. The Bonds family sold that parcel as well as the uphill parcel to the Longneckers, who owned both of them together as well. The Longneckers were the individuals that were the subject of enforcement, is OA 0550. And then when we fast forward to 2020, Mr. Anderson purchased this property and he granted a life estate to Miss Lenny Knight here, who's next to me. They have this hillside portion, but not the uphill portion where you can actually access where the shed site is. So this came before the board in July of 2021. If I recall, I think that may have been Member Kanto's first board meeting on that one. And the outcome of that meeting was that we're trying to figure out a way to make sure the safety of the downhill homes and structures here are maintained, while also trying to minimize the visibility of this storage shed that was there. So Mr. Anderson and Ms. Knight, subject to the board's conditions, retained a geotechnical engineer as well as a civil engineer, who both provided reports concerning what they thought could be done and whether or not the structure could safely remain in a more capacity without jeopardizing those that are downhill. So Mr. Anderson and Ms. Knight had the structure dismantled where feasible, which was consistent with the civil engineer's recommendations in their report. And then they had, where feasible again, materials removed. So in order to move materials off of this hillside, if I can direct the board to Exhibit 9 of my testimony. This is a photo of the stairwell. And if you flip to Exhibit 10 as well, you can see what it looked like at the time that this structure was being addressed. So in 2021, it's basically being held together by strapping to keep that landing up there. And you're doing kind of a switchback setup to get up the hillside. So anything that's being removed from there has to be carried by hand. So you're limited both by the number of people that can carry it, by the dimensions of the items that you're moving out of there, since you have to constantly be navigating by the stairs as well as by the weight. So when this structure is being dismantled, in order to avoid fire risks, Mr. Anderson directed the contractors not to bring torches out there to cut stuff and not to bring grinding equipment. So we're kind of a little strapped in what can be done technically in order to get these materials down to a reasonable size to move them out of there. So that's why we see there's still materials there today. And the way they've been stored on site is to try to minimize their risk of rolling downhill and to minimize their risk of catching wind. Since this work was completed in the end of 2021, Mr. Longnecker has revoked Mr. Anderson and Ms. Knight's access to this portion of the property utilizing his lot. So we no longer have that uphill access. Where you could potentially access the property from is the Pacui Street end, which, if I can direct the board's attention to Exhibit 3 with my testimony, if you look at the yellow dot that's on there, that's the Pacui Street end. And if you look at the purple dot, that's this shed site. Traversing from one end to the other, while you might be able to do it kind of by rock climbing, isn't going to be feasible for contractors to get up there with equipment, you know, shy of cutting a trail or a roadway there, which is obviously going to have devastating effects on the hillside, the stability in the environment. So we're placed in a situation now where we have the shed site essentially inaccessible. So if there are any further work to be done, there's not a really viable way of doing it. Mr. Anderson looked into doing sling loads by a helicopter to get that out of there. Given the dense development in the area, that was not a feasible option. So that's all to say that if we wanted to do more, it doesn't appear to be technically feasible. But I'd like to take a step back and kind of look at the first point. So what the board required when this went through here in 2021 was that a geotechnical and civil engineer be retained, that they provide their professional opinions on what could be done, and that Mr. Anderson and Ms. Knight carry out that work. At the end of all their work, the civil engineer, whose scope of work included the dismantling and the removal or feasible, said that he was satisfied that his recommended work had been completed. So it looks like all the conditions have been satisfied, and that's really kind of the thrust of the disagreement between the department and Mr. Anderson and Ms. Knight. So happy to take any questions the board may have. I'm also joined by Mr. Anderson and Ms. Knight's consultant, Joe Lancourt here, who oversaw the project.
Okay, thank you. Board members, any questions?
It's a lot to read and digest. Just following, from the get-go. So what is it right now that's on the property that's not acceptable to the department today? What is it? What's there right now?
I defer to staff for their position, but my understanding is that it is the height of the structure, which has the footing portion of the foundation. And I apologize if I'm butchering the technical aspects of that. Mr. Lancourt can speak more to what the foundation is there. And then potentially also the debris. So if we look at Exhibit 4, and I'm going to direct you to page 32. My apologies.
I guess.
Let's do page 25. So we see here, this is the structure before it was dismantled. It's a two-story structure. So the individuals are sitting up on the second floor. There's another floor below there. And you can see the vertical columns. That's what remains today, is the vertical columns. So that portion where the individuals are sitting is gone. The roof is gone.
It's gone. So what's there now? Just the columns?
Yeah, can I have you advance the slide, please, Athena? Next. Let's go to the one entitled Exhibit 12. So this is the area that we're looking at. And if you can go to the next slide. So the structure you're seeing there with the kind of rust-colored roof, That's one of the picnic shelters. That's not an issue here. Up above that, you can slightly make out some of the vertical columns where Athena is circling. That's the structure we're talking about, and that's what's left.
Okay, I guess I want to hear from others.
I think there's a copy of the agenda.
Yeah, but I don't know, I'd rather hear from the board. member.
Okay, so what's remaining now are the columns.
As you see it, yes, ma'am.
So there's the columns, and I'll try to get you a bird's eye here.
This is my second floor removal.
So that was during work. And I believe the staff submittal has some overheads of this. Are in Exhibit F of the staff submittals, their drone footage taken in June of 2022. So that's where we can see the overhead view of what's there. So it's the columns, it's the tied in floor, and the dismantled materials that cannot be removed. So once we get to dismantling it further, we start getting into issues of compromising the stability of what's left. And we get into a situation where there's potentially more risk downhill or of collapse if you keep dismantling further. We're limited in what can be brought off site. So it's kind of the happy medium of taking down what you can, and removing what you can, while not increasing risk or jeopardy to those downhill.
My next question is, when construction was going on, how was this material actually being brought down?
That's a great question, and one that I wondered today. So this was originally built in sometime in the late 80s, early 90s timeframe. Didn't have a clear answer. When this came before the board in July of 2021, I think Mr. Lemo acknowledged as well that it's just not clear how it got there. It's quite a lot of material to get down there, but don't know. Again, Mr. Anderson, Ms. Knight purchased this property in 2020. So it's kind of unclear what happened to construct it beforehand.
Okay, so follow up on that. As I was reading, board approved the CDUP OA 1803 for 12 picnic shelters and 1 storage shed.
Correct.
Okay, did the storage shed actually turn into this, what now is this house that we're looking at?
So what we see retrospectively from what was submitted in the CDUA and what was actually built are not the same storage shed. So I think the plans for the storage shed that were in that CDUP that was approved was somewhere along the lines of an 8x10 structure. That's obviously not what this is. And again, that was constructed by the Bonds family. So understand that this is larger than was spit on the plans, but not entirely clear if it was just always built this way, if it was enlarged in the 80s or 90s, or what specifically happened with that.
Follow-up question on that. So when you bought the property, did you know that this building was not in compliance with county ordinance or even the permits?
Sure. So Mr. Anderson, Ms. Knight, during their diligence, reviewed the OCCL files, and they spoke with, I believe, both Mr. Lemo and Mr. Kane. So what they see is that there is a circa 2005, 2006 enforcement action. I believe Mr. Lemo said it's open, but beyond that, kind of unclear how to resolve it. They were informed that it did need to be resolved, but not entirely clear how that was to be the case at that point in time. And we got some resolution on that at the July 2021 board meeting.
You good, Member Ono? Member Smith?
I have some questions for staff.
Yeah, before that, sorry, Riley. So the Bonds family built this structure.
That's my understanding, yes.
The Longer Neckers took over right?
Correct. And they were cited in 2005 for making improvements to the structure, which I believe were interior improvements.
Right. Did the Longeneckers know that there was a non-compliance?
I can hazard a guess, but I don't know. I've not spoken with them on this.
And what's the reason that the Longeneckers are revoking access from the uphill side?
So they had given access, I believe it was a courtesy or whatnot one time to perform the work that was to be done. My understanding is that after that work was completed in the tail end of 2021, discussions or something along the lines of additional issues that had to do with the Longneckers parcel that may be encroaching into the conservation district or may not be permitted or something along those lines caused some sort of pilikia or something there. And I don't know if that's the only reason, but it seems to have possibly been a factor in why that was revoked.
So there's an interpersonal issue between the Longeneckers and Ms. Nyden. No?
I don't know if it's necessarily in between them. I think maybe if we gather all three between Mr. Anderson and Ms. Knight, the Longneckers and OCCL, I think somewhere in between there, as we get that all together, there's something that's maybe influencing that, but not clear as to the Longneckers' specific motives or viewpoints.
Okay.
I think it was just a courtesy for the first time, but the second time they said that they didn't want to do it anymore because it really had nothing to do with them. This is their property. We already bought the other property. So the first access was just for the first time, just to accommodate what the department wanted us to do.
Right. Are they aware of the pickle that you're in right now?
I believe so.
Okay. And they've not tried to
So it's tough. 'cause
accommodate?
They're not obligated to, right?
Yeah, I know,
If they
I know.
fall outside the conservation
I know.
district.
I know. I'm just trying to, what the temperature is over there because it's almost impossible to access it from down.
If I may.
Correct.
Yes.
Why don't you pull up the chair, sir,
Okay.
and
I'm
introduce
getting kind of
yourself?
foolish.
Yeah, that's okay.
My name's Anderson. I'm not sure I haven't been terminated, but I haven't got my letter yet.
Yeah.
He was accommodating. We had to take out insurance liability before we went on his property against anybody getting hurt. So we had to insure the entire project, and we did. And those insurance policies lapsed, after the job was done and the engineer signed up. Surfaced another issue was encroachment. After 37 years, there was suspect of encroachment by him. I called and asked to see his title report because our title report was clean. He said his title report was clean, but the very accusation, and I guess through the experience that he went through with the land board earlier, he kind of slammed the door on us. Don't ever come back. I've had enough, etc. So that's where we are. He kind of concluded enough is enough. He had clean title. We had clean title, but he was still being kept into this, and he denied any more access.
I see. So you guys don't speak anymore?
We speak. I mean, it's a business decision with them.
Sure.
But we're not social friends. I have to call him and find him. I think he's living on Kauai. This is all rentals now.
Yeah.
But no, he's been very cordial, but I think he spent $50,000 renovating, removing the renovation that his brother made on the shed illegally, the first NOV. And so he's kind of bitter.
Okay.
He came before you with his attorney. He argued, you accused him of building the shed, which would have made it an unauthorized shed. And he said he didn't build it, it was there, and you didn't believe him. And a year later, you admitted he was right, and you didn't tear up the citation even after admitting it. So he's a bitter man when it comes to DLNR, OCCL.
What year was this?
Huh?
What year was this?
So this enforcement, I believe, came before the board in 2006.
Oh, it's before our time, so I feel better now. Just kidding. Just kidding. Okay, 2006, all right.
So the enforcement action was OA 0550 on that one.
I've been asked several times, didn't you do your due diligence? And we did. And we bought the property for her, knowing what the problem was. I mean, I was working with Mr. Sam Lemo. He explained, I think we dealt with Mr. Fitzpatrick the first time, and then Mr. McCain took us, McCain took us to the library. So we were aware, but reading everything from the beginning, who should have been cited for an NOV versus who was cited for building it, Longnecker. You should have cited Mr. Bonds for an NOV. So when Mr. Longnecker bought it, there was no standing violation. There was no reason for him to not buy it. Then when you accused him of building it, after the fact, you imposed this new NOV on him. And this is the monster that we're dealing with today. But we thought sitting down with reasonable people, taking it back to the beginning, it would have been cured. So I guess I mistakenly advised her. I was hired for nothing as a volunteer to save her money. And I think I've caused her to spend money, unfortunately. And it's an agenda item to us, and it's legitimate, some of it. But it's a dream to her. It's a home. You've got 365,000 square feet on 8 acres. She would be allowed to build 5,000 footprint. Has no use to the back of the land. She's agreed never to go back there, never use the shed. So it's a different priority. She has a dream home. You know, we have an item before us.
Okay, so that we're clear, Mr. Longnecker's primary issue is with the decision and imposition of the board, whatever happened in 2006. Is that correct?
One more time, please.
Mr. Longernecker's primary issue is the way and manner in which the board treated the situation back in 2006.
Yes, his hearing.
Okay, thank you very much. Board members, any other questions for owners? Okay, Trevor, you want to come back up?
Do you guys want to see if there's any public testimony before we come?
Oh, yeah, thank you. Is there any public testimony on this issue? Okay, sir, you want to come up? Thank you.
Stay here, Andy. I'd like to have you part of this.
No, I'll sit here, thank you.
And Lenny, please stay here, okay?
Okay, I'll sit here. You want me to hold your hand?
Probably. I'm sorry. My name is Red Mahan, okay?
I just met him today, by the way.
I'm a fan of her work, and first of all, it's her birthday. Happy birthday.
And Eric's birthday.
And your birthday too.
Tomorrow.
Wow, wonderful.
Happy birthday.
Actually, my birthday is tomorrow, but technically I was born in the Philippines, so it's 23rd in the Philippines. But my children, just want to let you know, they were born and raised here in Hawaii, and then they bought a home in Palolo. They've been there for a long time. So I just kind of wanted to see if I could have a small home, rose garden, my studio in this massive, beautiful 360,000 square feet. And I don't have any need for all that other stuff that's been there for thousands of years. And so that's it. And I just met you today.
Thank you, and happy birthday to you both. Okay, Mr. Mahan, go ahead.
I think the first thing I would like to say is, using Andy's words, we're all in this together. How do we find a way forward to solve a problem that has plagued our community? So kind of, if you would, in a spirit, I feel like we're all holding hands right here, right now. We're not going to solve this situation alone. One person, one man. It's going to take all of us. This is a microcosm of what's happening to Hawaii. We can no longer use the old laws that don't serve us anymore. We need to find a way forward that honors also the wisdom of the ancestors that were here before, from my perspective. I might be the man I might be the most knowledgeable man alive on that parcel of land. I have walked most of that parcel, okay? I refrain. I have crawled and stumbled through most of that parcel. I am not the problem here. The problem is that these folks will encounter is making what they're proposing palatable to the community at large. Because it's like finding an old car, that's valuable old car in the woods, and you go, hey, I really would like to renovate this and get it going down the road, but I've got to get it safety checked first, okay? I got to take it to the safety check and have it looked at, and then I can get it now. Oh, I've got to also get the registration up too. So in this case, we have, and I need to also put a disclaimer there. I know Longnecker real well. I know who built onto that addition, his step brother, and why he did it. Greg was just trying to help his brother out because his brother has some substance issues, and he was trying to help him out and give him some employment and keep him close to home, if you will. Unbeknownst to them, of course, it is conservation district land and they got cited. I know the guy, Kevin Davis, that drew the drawings for that. I also know okay, 30 seconds left.
Question for him.
You have 30 seconds left.
It is as Andy has said, as the engineer has said, as the architect has said, this is a very, very dangerous situation. It needs to be dealt with very carefully. There are existing land uses on there that not me, but some attorney who knows what they're doing will come in and ram it down all of our throats that these land uses have to be corrected, very much like the TMT.
Okay, thank you, Mr. Mahan, for your, any questions for Mr. Mahan?
No, please, you got, your time is up.
Okay.
Okay, sir. So you just met this young lady today?
Yes.
Is that correct? You've been on the property for how long?
I have owned my parcel for about 5 years now, 4 years.
Within the same,
No, I think some clarification if I may.
sure.
There is a paper.
Can you please just come up? and-
Excuse me, yes.
Yeah, just for
I'm
the
sorry.
record, yep,
It needs to be clarified.
okay.
If you look at the map,
Have
there
a
is
seat,
a,
sir, and reintroduce yourself.
I'm
just for the
sorry,
record.
sir.
Yep,
there's a paper road off of Pakui going right up the mountain.
Mr. Anderson, right?
Yeah,
Yes,
Andy,
yeah.
yes.
Okay, gotcha.
For
There's
the
a,
record.
I'm sorry. Yes, Andy Anderson.
Okay.
There's a paper road on the TMK that goes from Pakui Street off of her property right up to the water tank. It's about 50 or 60 foot wide. Mr. Mahan lives on that questionable road. He has how do you describe the walls?
I'm not here to.
No, but they need to understand that he's living on this easement. He didn't acquire it. He's actually on also a border water easement that under him 3 feet is a 14-inch water main that if it ever breaks,
It's a
or if he
16-inch
digs,
water main.
yes, there is, sir. There's a border water easement on the right side that is on the property. So it's in a questionable occupancy.
Okay.
That will be resolved at another time.
Sure, okay,
Thank you.
Nothing to do with her lot.
okay, I understand. Thank you.
Okay.
Any other questions?
I think I understand. It just confused me when she just met you and you're occupying
Not her.
land.
He's occupying a potential paper road that's on the map.
Separate parcel.
Separate parcel.
Separate parcel.
Yeah.
Okay, all right.
Okay.
Did I say that accurately?
No, sir.
Okay.
Well,
then
I
you-
think we
Okay.
got the gist
Okay.
of it. Board members, any
Thank
other
you.
questions for either one? Okay, staff, if you could return, thank you.
Can you
Ms.
come
Knight.
there?
No, we're gonna, yeah, staff.
Oh, stop, sorry.
Unless you want to work for the DLNR on your birthday.
Come
Just
sit
kidding.
here, just kidding.
Okay. Member Smith?
Thank you, Trevor. So, couple questions. So in our packet under Exhibit D, there's a July 13th, 2021 letter from Sam Lemo to Mr. Anderson identifying the 13 conditions in order to achieve resolution of this issue. What is OCCL's position on which one of these, if any, have been satisfactorily addressed?
I know there's been a deed recordation. And then regarding whether or not the structure has been satisfactorily removed, we don't feel so. And I know there was a question earlier about what's there. If you look at Exhibit B1 on page 3 of the exhibits, that is a drone photo we took in, sorry, and it's incorrectly labeled, but June 1st, 2022, with Mr. Anderson's permission. And we were under the impression that the structure could be removed down to its footings, according to the civil and geotechnicals reports. That does not look like it's been removed down to its footings. So really the question we think before the board is whether or not you all are satisfied with Mr. Anderson's and Ms. Knight's removal efforts.
And Trevor, so you and OCCL is saying that you're willing to waive item number 11?
Yes.
Okay, so the 15,000 fine per day, you're willing to waive that?
Yes, I mean, according to, again, Mr. Anderson, Ms. Knight, there's no access to the parcel, so we don't feel exactly that it's fair that he be financially penalized for not being able to further remove it. However, he is still welcome to propose resolutions and mitigation to further try to remediate the situation. That will, if it's requires a proposed land use in the conservation district, that will require our review and potentially would need authorization from you guys as well.
Okay. So another exhibit in our packet, Exhibit C1, dated December 5th, 2018. Ms. Knight, before she purchased the property, asked the administrator of OCCL whether there are any issues. Correct? And then he sent the letter on April 12th, 2019, that's Exhibit C, which identifies the unresolved issues on the property. That's accurate?
That's accurate.
Okay. So on or about June of 2020, Ms. Knight closed on the sale of the property. Sometime in 2020.
Yeah.
Okay. And then on July 13th, 2021, this Exhibit D, Mr. Lemo sent another letter to Mr. Anderson and Ms. Knight identifying the 13 issues that he wanted resolved. And Ms. Knight or somebody acknowledged that they received that. I'm not sure whose signature that is.
Well, I would just clarify the letter OCCL issued signed by Mr. Lemo on July 13th. That was the board's decision when we brought the matter back to the board. And the 13 conditions are what the board decided Mr. Anderson and Ms. Knight needed to do in order to resolve the issue. We believe the signature is Mr. Anderson's or Ms. Knight's.
Okay. As landowner. Okay. So in 2021, they acknowledge all these conditions. And OCCL doesn't feel that the conditions have been met. But the Andersons and Knight feel that it has been. Is that accurate?
That sounds accurate to me, yes.
Okay. So I mean, we just need to figure out whether these 13 conditions were complied with or not. And if we agree that they're complied with, they're over and done with. And if we don't feel they're complied with, then you got to comply.
Or they need to figure out a resolution.
Figure a resolution.
Yeah.
Come up with a settlement with you folks.
I don't know about a settlement, but I think they would still need to remediate the structure or what's left of the structure. And then beyond that, as we've identified and notified Mr. Anderson, there appears to be encroachments on the property that from the neighbors that he's gonna need to resolve with them in order to essentially clear the property for future applications. As noted in the report, if you guys recall, in December, there was a landowner in Kaneohe, I think Alio Manu, who was requesting a time extension to complete their SFR and had opined about how she had to remove 3 tons of garbage from the property, as well as notify 24 adjacent landowners that they were encroaching and had to resolve that.
Okay. And as I go back to Exhibit C, the one dated April 12th, 2019, Mr. Lemo tells the buyer of the property, the burden to resolve any land use violation in the conservation district rests with the landowner of a subject parcel. So irregardless of who have built the original structure, all these issues were clearly agreed to before closing, and they made an effort to do something, but OCCL doesn't feel that it complies with the 13 conditions in Mr. Lemo's letter, right? Okay.
Well, again, I would say it's the board's decision that we outlined in
Got it.
Mr. Lemo's letter. Yeah.
Member Char, do you have any questions?
I'm confused on who did what. The removal of the top roof of the shed was done by whom and when was that done? Has Anderson done any work with regard to that piece of property up there?
I'm sorry.
I'm trying to figure out who did what at what in what timeframes. Was any work done with reference to that structure? Because somebody removed what looks like the roof, but left the floor and the foundation and
If I may, board member Char, Exhibit B. This was the drone photo we took prior to bringing the
Right.
matter in
it looks
July.
like somebody removed the roof of that.
So this is what the structure looks like after Mr. Anderson. This is what the structure looked like on June 1st, 2022, after Mr. Anderson and his agents, quote unquote, had done the removal work.
So Mr. Anderson did remove the roof of what remains there, but left the debris and the floor and then
the columns.
The columns both on the floor and below the floor down to the foundation.
Am I allowed to sit alongside of?
Hold on, Mr. Anderson.
Yeah.
So it appeared he removed the roof, the second floor, and then the columns and the first floor are what still appears to be there.
The roof was removed. Was the floor also removed?
The second floor.
Second floor slab.
Oh, the second floor. Is there another floor?
It appears so, yes.
First floor slab.
Oh, so it's 2 floors then. Okay. So is it the contention of OCCA that it was only partial correction and not the additional floor and columns?
Yeah, I mean, their geotech and civil was down to the footings. We had requested more information from Mr. Anderson once he had submitted that information, and he basically just referenced that we'll do what the geotech and civil reports will do, remove to the footings, and you can see in Exhibit B1, I don't think that's down to the footings.
Okay, I understand.
Any other questions or comments for staff? Is the geotech or architect or structure engineer here? Sir, could you come up for a sec? Please introduce yourself for the record.
My name is Joe Landcore. I'm an architect.
God bless you. I'm a recovering architect. Oh, we got a lot of recovering attorneys here.
I would like to and retire.
Yeah. Well, go ahead, Joe.
There's a lot of stuff going on that's inaccurate here. And This may take you, unfortunately, an explanation of engineering terms, but foundation is one thing, structure is another. Big time differences, like when you're talking like Manhattan, where you've got a high rise or you've got a building that's going to float like $1,100 Kia or something. So oftentimes a foundation that, well, the ACI, American Concrete Institute, publishes volumes on this, and they are the holy grail or the Bible for the field of engineering and architects and insurance companies and building codes. And so foundation for, if you go to the ACI and you look up hillside foundations, you will see what looks like is still standing on that site now today after the work was completed. Mr. Char, to clarify for you, yes, the roof was removed and the roof structure and the columns and walls that went down to the floor, and the floor, the wood structural floor that was gone, everything that was structural, Ken Hayashida was Ken Hayashida is both our consultant. He's both structural and civil. And what his job is, he clearly understands foundation and structure. Nobody wants to tear into a hillside foundation that is built on rock. And if you go back to the original WYDIG report, he tells it very, very clearly that it is founded on rock, and that means it's solid. So it's going to stay there if you don't mess with the concrete and the rebar. And by the way, you asked, how did they get there? It's because they had an open site above and they pump liquid concrete down. It doesn't pump back, especially once it's all consolidated and all that. That's how they got it there. It's just amazing. And they worked really hard at it. But what they've got is a textbook example of ACI's hillside foundation structure, which is the what people are calling footers, footings, and all that kind of terminology, which doesn't really match technically. Foundation is the correct terminology, and the foundation includes the grade beams, the bearing points, and the vertical concrete structure that takes into account the lateral loadings, the wind loading, and all of that. And so that thing is tied together. You don't want to mess with the concrete work that's there. All of the woodwork, all of the structure is gone. They took all of that out. Concrete work doesn't come apart as a stick that you can carry up a stairway, no matter how steep it is. It's a chipper and then making sparks with cutting rebar. And then you've got a compromised, unengineered thing sitting on the hillside that nobody had any engineering responsibility for. What's there is the foundation, not the structure. The entire structure, which was a couple of floors of it. Or, I mean, in some places it was, that thing was a stepping down the hillside thing, but all the woodwork has been, all the structure is gone. What's left is clearly foundation by anybody's terminology, including the one WYDIG had from way back, prior report.
Exhibit 6 to my testimony, the date stamping on there is page 54. It's the top, and I'll just read it for you. The pavilion foundation consists primarily of 14 to 24 inch square isolated concrete column footings based on intact rock.
Based on intact rock. That's, he confirmed that the thing is going to stay there. And so no one wants to partially take out part of a foundation. No one wants responsibility to mess with that. It's a competent structure.
Thank you, sir.
But that includes the flooring.
The floors are gone.
But this looks like a solid piece.
There's a lid, there's a concrete tie from the retaining walls that transfers lateral forces into the what's remaining of the foundation.
And looks like a lot of debris here up on top.
That I don't speak to.
That needed to be stored somewhere on site because it could not be removed off of
So,
there.
I mean, is this, here I'm referring to exhibit B1. So there's columns here and then columns underneath, and then there's a solid.
Yeah, the columns are all hillside foundation.
Okay.
That's all standard stuff.
What is all this stuff here? Debris?
The dismantled materials. And if I may, I think it's for context, it's important to refer to the structural engineer's report. So this is Exhibit E to the staff submittal on page 12. And what the structural engineer recommended in his report was that he notes the structure is slowly deteriorating and it should be dismantled where feasible and removed. And then in a note, as access to the shed is difficult, the shed material should be removed to the extent it could be done safely. So it has to be removed by hand up broken stairs at the time. And we're dealing with large pieces of structure that can't be cut down and that are going to be limited by how much two people can carry, how much they can do on all the switchbacks of steps and everything. So that's why we still see a lot of stuff remaining there today.
So under your feasibility study, you're saying that all of this material here, looks like boards or whatever, cannot be removed because it's not feasible because they can't carry it out?
At the time, correct. And now it's not feasible for an additional reason because we can't even access the property on that portion.
That's the long Necker property burning. Member Canto?
Sorry, I'm a little distracted because the gentleman in the back against the wall is doing this. And I was like, I'm distracted. But for you, sir, I have a question. We have a structural engineer here and we have.
No, we have an architect.
No, well, no, okay, so we have an issue.
Big difference.
Yeah, I know.
We went to more
So-
school.
okay,
No, just
stop
kidding.
it. So we have, stop it. So we have a structural engineer over here and we have a mechanical engineer over here.
Geotechnical.
Geotech, okay, so when the home was built, would there have been a civil grading issue to be completed? When the home, well, I don't know if you would know this.
Can't speak to it. It was back in the late 80s, early 90s timeframe.
Because civil, I mean, they'd have to dig in and.
That's it.
So
concrete.
in connection with enforcement OA 0550, there were some structural plans that were included in the CDUA that they submitted after that. And that is on Exhibit 4 of my testimony on page 32. So you can see their rendering of what the structure was. And you can see the footings and kind of those sorts of drawings there. I think that might be the closest thing that is available in the record or evidence today of what some sort of engineering work may have been at the time.
Okay, well, I just want to understand.
So that was, I'm sorry.
No,
Member
go
Canto.
ahead, go ahead.
So those drawings, are they post-construction or they were used to construct?
So for enforcement OA 0550, the requirement that came out of that was that the long neckers needed to submit a CDUA.
Okay.
So they had plans, not entirely clear from the record if it's only what was there or if there was some stuff that was added on. Like we see that in the file there, that there are some questions from OCCL about, is there anything you're adding on or improving here? Or is this just what's there? With respect to the foundation part, we'll see there's some cross sections of like the columns that are in there. And you see that they've got rebar going up vertically, rebar going horizontally on that.
Definitely engineered. So DPP has no record of this?
I understand they've got some building permits on file and the OCCL requested it. I didn't see kind of a formal response on that in terms of the drawings that were submitted. So I'm unaware.
Okay. Okay, Joe. So Ken Hayashida is the structural engineer, correct?
He's civil and structural. Yeah.
He's civil and structural, but in his structural hat, he's saying that, not foregoing the debris, and I see some non-load bearing partition walls, but as far as the columns and the lateral force slab that you see there, Ken is saying it would be hazardous to remove it.
There was some long, heavy steel window frame sections that were too difficult to wrestle out of there. So they laid them on the ground within the grade beams.
I see. Okay.
The wood you're seeing also is formwork that wasn't removed from poured in place cast retaining wall. That's that plywood and studs you're seeing there.
Yeah, okay.
That's the formwork.
Oh,
That's the retaining wall, and they left it.
Okay. All right. So if the formwork were removed and the debris, and we'll get to the viability and the manpower in a second, but let's just hypothetically say the formwork and the debris left were removed, right? Let's just entertain that discussion for a second. OCCL, would that suffice, or in your opinion? So if the, yeah, come on up, Scott.
And can you point it to on the?
Yeah, I'm
picture?
looking at the exhibit D1. So Joe just substantiate or just clarified that wood vertical, this piece right here, those are the forms for the, okay, so if the forms were removed and the debris that were stored here were removed, in effect, I'm gonna guess that what's left are the columns and the lateral load bearing slab, correct? So, right?
Yes.
Okay. So if those are removed and the lateral load bearing staff and the columns were to remain, would that suffice?
I think we would like to see if it could be even the columns reduced. I mean, I drove eastbound on YLI yesterday and I can see this from YLI.
Okay.
So just one point of clarification. There are additional structures that are visible. I think if we're looking from down below, this actual shed is minimally visible because we see one or two columns there. Just kind of from my own experience of having gone up and down there in the past week or two, and then being there for the photos that we have in our stuff, we're taking on Tuesday. So we get bird's eye and kind of a lower perspective on that as well.
Okay. Member Coffin?
Okay.
Okay. Okay, so it's OCCL or staff recommendation that, let me get this. So we remove the forms, move the debris, and let's just now hypothetically say we can remove the lateral load bearing slab and cut the columns down to, I don't know, 6 inches above finished grade, something like that. If that's what you would recommend.
I think we would be more comfortable with that. Yeah.
Okay. Would you guys be comfortable with that?
No. The engineering, I'm sorry, a layman's idea of what a foundation is competent, when we've got 3 engineers saying that that foundation as it exists is competent and founded on rock, causes one to have comfort for the houses below, and to end up modifying that foundation and then finding out later that, oh, that's why that thing slid down the hill. The idea of messing with the foundation is, I don't think you'd get any engineer to take the responsibility for it. I think that's an extremely unwise move.
Yeah, Joe, I was just hypothetically throwing out there because I'm trying to find the middle point. So we
Yeah.
went through one extreme to the other extreme, and then somewhere in between, we gotta come to resolution. So yeah, I understand what you're saying, and I know Ken Hayashida is very conservative, but remember Char?
Yeah, I'm just following up. If the columns remain, including on the ground, and the lateral tying them all together, if it's your position and that also is part of the foundation, and I can understand that. But what I don't understand is this, all these stuff here, looks like boards or whatever, here, and I'm sure probably some underneath. If what you're saying there is, your second argument is you don't have access now. I'm trying to differentiate between, what mechanically is possible and what is, a difficulty.
I believe your understanding is correct, and that the difficulty on the debris is accessibility. Some of the material that's steel and heavy and long is really difficult to get out, and that's
Okay.
why the helicopter thing was.
I understand that as another argument, but at least from an engineering standpoint, these, what looks like sticks or whatever, that's not part of the foundation. That's not part of your professional statement that it's required to keep the foundation in place. That is not foundation. So one of the things I guess we should ask you then is, from your profession, what is not foundation on this picture?
I couldn't tell from that picture, and because we're getting so precise on things, I'd say everything that's concrete that's there still is foundation. I'm just basing on what Ken Hayashida told me afterwards, that that the structure is gone.
But you will admit, looking at this picture, which was a drone picture, that there are non-foundation items on the property currently.
It looks, it's hard for me to tell what that is with my eyes and across the table like this. Okay, it's closer. We're back to that thing of what's it possible to get out of there.
Well, then, no, answer my question. What I'd like to know is whether it's foundation or non-foundation, separate and apart from the difficulty of removing anything.
Concrete, whatever you see there as concrete is foundation.
And what is not concrete, therefore, is not foundation. Is that what you're saying?
That isn't the way I'm saying it, but yes.
Okay, okay. And you have no opinion one way or the other as to removing the items?
I have a strong opinion as to that. That's like virtually impossible. They won't fly the helicopters in there because of the FAA, because they investigated that quite carefully, tried different helicopter companies, and nobody will do it because of all the people living there, and they want the flight path clear too. And anyway, and the method of getting it out going downhill is dangerous.
What's the linear distance from the top to the bottom?
That I don't have off the top of my head. Let's see here.
Yes, well fun.
Good. We've got meets and bounds in here, I believe, somewhere.
What's the distance from this site to the bottom?
1,000 feet plus.
About 1,000 feet.
That's the lateral, so.
We looked at bulldozing a road up, but you would never approve a road with all the earth movement in the rocks.
You don't know what we'd approve, so. But what I do know is we can't keep going down the same avenue and expecting different outcomes, right?
Well, if I may, in my addendum I sent you, why we're here today, all the other conditions we've agreed to, and we satisfied the recording, et cetera, et cetera. It's the reading of number 10. That's why we're here today. I think Miss Mills will agree, right? She's shaking her head yes. We disagree. There's a misunderstanding or there's a disagreement of the reading of number 10.
And just to add on to that, I think it's important for context here. If we look at condition number 4, the requirements that the current or future landowner shall complete all work as recommended by the geotechnical and civil engineers reports. So I think had Mr. Hayashida not submitted his December letter saying that he's satisfied his work was completed, I could totally understand the department's position on number 10. But here we're placed in a situation where he has said something. So it's kind of how far can we be reasonable in contravening that or disagreeing with
I
it.
understand. Okay, so
if you read number 10.
Yeah, I read it.
Reread it, that it limits OCCL to be satisfied that the landowner completed the work as per the engineer's report.
Got it. Yep.
The engineer said we did.
I got it. Thank you. Thank you, Mr. Anderson. I appreciate that. Okay, so how many feet down?
It looks like it's somewhere between 200 and 300 feet on the
Okay, so 200 to 300 feet. And you probably have contemplated this.
ballpark.
Yeah, that's fine. Let's say 500. Okay. Was there any proposal to use the grade and gravity to feed the material down 500 feet?
We looked at and it works for lightweight common lumber, not steel.
Okay,
If the steel gets away from them,
okay, so the forms could be done. The loose other little debris could be done, right?
if you look at the darn, if you look at the darn, I'm trying to agree with you, but let me, if it was
have
you
to
and
agree
me
with me.
trying to figure out how the hell to do this, yeah, well, look at this first picture, the very first one you open up, look at that slope
Yeah,
from
I
there.
know, I know.
I mean, it's dangerous.
It's-
So you're gonna use a rope, you bundle the stuff up and put it in a bag and
Yeah, I'm just trying to, let's just talk this through, because we don't have a lot of time. I don't want to spend too much time on this, but it's not right, what's impossible right now is to access the site, the upper site. So let's just get that out of the way. So let's go down, right? It's not impossible for lightweight material, wood and such, right? Might take some time, but we're not walking up switchback stairs and breaking our backs and then dealing with Mr. Longnecker, correct?
Correct.
Okay, steel. That, once we clear up all of that debris in the forms, we're left with essentially a large open concrete slab, correct?
Mhm.
Okay.
Well, there's a dirt area in between the grade beams and all that, yeah,
Why couldn't you torch on that slab for the steel?
on the hillside.
No, on the slab.
Do what?
You cut the steel,
Concerns about sparks and everything. and
sparks in it,
fire.
right? But if you're on this large concrete pad, right, all of this debris is gone. And I'm up there with a torch, which is enough room, I think, to cut.
So you got the torch bottles that you gotta get up there
Yeah.
somehow.
Yeah.
And then you've got to get somebody who's knowledgeable and skilled enough that it's not, you don't send an amateur up there with a torch on a dry, I mean, not in summer, hopefully it's after a rain. And I think it's very hazardous and the liability
Could you
is,
just have a seat, please? Thank you.
the liability would be shocking of
Oh,
doing
you
that.
cannot hear.
And-
Oh, have a seat. Come over here.
And
Speak up next time. No, I'm just kidding.
He did say that.
Oh, so I cannot hear.
say you manage to get the steel all cut up into smaller pieces.
Yep.
Now you've got to get it down. And you wouldn't want to consolidate it. You wouldn't want to bundle because it's still heavy and you'd be trying to feed it down and it'd be like, remember the movie The Great Escape? It'd be like, put it in your pocket and then crawl back down.
Yeah, okay, all right.
Yeah, but
I won't agree to that.
Yeah.
Just
Agree to
saying,
what?
Torching anything up
Oh,
there.
yeah.
No,
Yeah.
I'm just.
Just saying.
I could see the point if there was no slab there. That's why I'm just entertaining it, right? If this was just dry brush and trees, yeah, okay, but this is a huge slab, right? Either way, I don't think OCCL is gonna bend on not taking out non-structural material. Is that, I don't wanna speak for you guys, but is that, let's just start that as Roman numeral number 1, right? So we need to figure out a way, I think in good faith and in moving forward, how do we effectively move non-structural material from the site safely?
So I think that's a big challenge we're trying to resolve right now. So on the one hand, OCCL's position is that they want that stuff out.
Right.
But on the other hand, they're acknowledging that it's not feasible or doable. So we're locked in a position where we're needing to remediate this or mitigate it in order to do anything with the land, but OCCL is acknowledging that you can't actually remediate it or mitigate it because of the site constraints and because of access. So we're basically getting put in a position where the land's got no beneficial use and it's gonna sit there fallow in perpetuity. So I think we're wanting to avoid that.
We just walked through a possible, we talked about lightweight material, let's forget about the steel. We just came through a proposal that might be possible to effectively remove lightweight wood material.
Can I ask a question, please?
Sure.
What does it accomplish if in fact, removing it to the footings, a one-sentence objection, it could be moved to the footing, the engineer didn't say it should be moved to the footings, but let's say we agree. what are we accomplishing in going back and busting concrete?
Compliance within the
For what
conservation.
purpose? Are we creating more safety?
No.
I mean, some arbitrary, subjective.
Sir, I mean, one of our functions, major functions as a regulatory agency, and compliance is what, to your question, to answer you blandly, it's compliance. I mean, if we continue on this path, we are in non-compliance, which puts the board in an untenable position.
Only, and I'm not arguing, but only if you read number 10 differently.
Right, I got you.
I asked for an attorney general opinion. I asked how he would read this. If we can find agreement with number 10, be it a misunderstanding or
I got you.
So we can resolve everything. We're all wasting, a lot of time and money, but do you have a role in demanding more work? When the engineer says, I'm satisfied, Mrs. Knight is caught between OCCL's subjective opinion and the engineer you forced us to hire and report on. So you have a professional report saying one thing, and you have OCCL saying another, and whether they have the right to say another is in the question. So
yeah. So
how do you get number 10 resolved legally and get an opinion?
I understand. So Kai Hawaii, that's where Ken Hayashida works, right?
That's his company, yeah.
Yeah. So unfortunately for us, we're not Kai Hawaii, and Kai Hawaii doesn't have the same responsibility as the Board of Land and Natural Resources. So it's fine that Ken says he's okay, but we also have to trust and rely on our staff and their recommendation, whose job it is to comply. And it is our job to support compliance.
But it doesn't read that way, sir.
Yeah, I got you. So I'll address you in a second.
Okay.
Anything else, Joe, or?
So I think it'd be helpful to get the board's position then maybe on condition number 4, whether or not that's been complied with.
Yeah. Okay.
Can I make a statement?
Yep.
We're in a situation here where you need a majority of the board
Yes.
to resolve this situation.
Yes, sir.
So Kaiwi is trying to propose suggestions, and if we can walk out of here with agreement, then we have a solution to this problem.
Yes,
And
if I can live
No,
to
no,
the
no,
agreement,
Let
sir.
me finish. And if we don't come to an agreement, I'm gonna guess that 5 people are gonna say, I'm gonna support the staff.
Oh.
So if
I agree.
if there is some leeway,
Yeah, I think
possibly if there are maybe some aesthetic considerations. I mean, when I look at the aerial photos and I see all this white concrete, the contrast of the background, very noticeable. Maybe if it was painted or something, so it looked green, maybe that's something that OCCL would feel is more acceptable than not doing anything. It just seems like moving stuff is real
Yes,
complicated.
and that, I was getting to that, right, and that's fantastic. But right now, I'm just talking about loose debris, so I'll address you in a second, but I want to talk about what's possible, not impossible. So once we clear up the forms and the debris, okay, forget about the steel, let's put the steel on the side. To Member Smith's point, what then could be done is a different story. But for now, for us to okay in this condition, where it has nothing to do with Kai Hawaii, Ken Hayashida, or the structural integrity of the site, or safety to downhill homes, we cannot, at least I cannot say that, well, that's good. When I have staff telling me they want way more done. So to Member Smith's point, I'm trying to find the middle, and I hope we can, lest we vote quickly and expeditiously now.
Understood. So I think in terms of trying to get more removal out of the loose debris, I think we need to explore with some of the engineers and the people that actually be doing it to see
Non-structural debris.
if they understood. And thank you for the clarification. What can be done? So if it's going down slope, does the topography support that? Does the vegetation support that? Do we need to clear trees out of the way? And if something is at another land use, we need to come back to the board for. I think those sorts of kind of mapping out how it could be done if we do find a path. I I think we need to ascertain whether that's doable or not. And then with respect to Member Smith's point, I think the visuals, they are kind of stark with the contrast. But I also think it's important to note that the visuals we're looking at here are a bird's perspective in a lot of cases. So the elevation here is significantly above the rest of the land. So if you want to get to the same height, you've got to go back to the next ridge line, like a half mile away. If you're looking downslope from up above, it's more or less obscured by vegetation.
I got you. Here's kind of where, sorry, Member Char,
Yeah.
go ahead.
Just-
Sorry.
For instance, I'm looking at your exhibits that you gave us today, number 7. And this is the letter by Kai Hayashida. And in there is a picture of the work that they've done. Look at this one here.
Got it.
Okay, so his letter is to the effect, complete dismantling and removal of the shed structure. In my opinion, this completed the dismantling per the letter of recommendation. But in looking at the picture here, it looks like there's still a lot of material there, debris that's not foundation stuff that they've dismantled.
That
So-
was during construction.
Okay, so I'm not sure whether that's how they left it, because it certainly looks more like how they left it from.
The shed today, sir.
So there is loose debris there, just so we're all on the
That's the
same
shed
page on that.
today.
Well.
You're looking down.
I'm
you're-
also looking at this picture here, which is a,
B1.
Yes, you're looking down at the footprint, but this is from visibility.
okay, from a visibility, but then I'm also looking at
If you fly over the building, yes, you're gonna see that.
you can see a lot of what looks to be, to me, not foundation,
Yes,
but debris, just junk.
that debris, if I may I?
Yeah,
What you're calling debris, I guess you could call debris. I got a call from the could you go to number 13? Is it number 13? The interior of the building. For some reason, this architect used either 1/4 inch or 3/8 inch steel window and door frames.
okay,
Now, it's not just a question, we didn't take it because we didn't want to. We didn't negotiate a contract on dollars, saying you can't exceed $10, et cetera. We agreed to do the job as land board asked for. We. Did you find it? What is the existing shed?
Sorry, I'm gonna give you like one more minute.
In
so
the
we're gonna-
interior.
We're gonna move on.
Okay,
Okay,
but
go ahead.
we discovered a lot of steel frame and long material. We didn't allow a torch or grinders because we didn't want to start a fire. So there was just under that big pile of debris, a very big hole, like it went to the basement, but it was earth. So I approved, maybe wrongly, because they couldn't get it off site, not just because of the weight, but they couldn't even get out with that alley. If you saw the ingress, egress,
was that done after the drone picture? That you
Prior.
went down and,
no.
Prior to.
During the demolition, we instructed them to pile all the steel
right,
and all the material that they couldn't get off site into that big hole.
okay, but this drone picture seems to be after.
That's correct. It's approximately 6 months after
Okay.
work was completed.
And this drone picture shows me that it's more than foundation and window frames.
Or there might be some small pieces, but the 90% of it,
That's what we're talking about. though.
Yeah,
It
so
looks like,
yeah,
I'd
this big pile
yeah,
and here, this is all steel. You can see the steel there. Here's some steel.
what's all this and
Yeah.
these boards?
This board is concrete forming. That's a concrete wall
Okay,
that Mr. Longnecker's brother built
okay,
and got cited for.
okay.
Chair,
Form is still
All right.
contacted
I'm
to
gonna
the
call
wall.
order.
Chair,
Have a- Yep.
if I may, it sounds like the board would like to
Yep.
get some sort of sense of what feasibility there is for removing
I'm gonna get there in
debris.
a second. Any other questions or comments, board members? Okay, I'm gonna entertain a motion to defer this and have you guys come back at the next meeting with a plan, a viable plan to address non-structural material on site and its removal, safe removal. Let's start there. If there is no plan, I'm afraid we'll have to vote at that time. Now, to Member Smith's point, you know, if we can get somewhere, and let's say that, you know, let's just say slab stays. There are novel ways of addressing this. If you think about it, I'll give you one. What if you guys did a native Hawaiian nursery on this slab, growing only native species to help propagate native species for the state? Nope, nope, I'm sorry. So I'm not saying you should do that or paint it green, paint it brown, paint it pink. I'm not saying, we're not saying any of that. But what I think I hear the board members saying, and some of the, I guess, the pushback or frustration is that this particular issue should not come to the board for us to solve. We have a recommendation from staff. We can rule right now. Right? We can expeditiously rule on this right now because it's in non-compliance. I don't care what the structural engineer says or anybody else. Right? Our staff is telling us it's in non-compliance. The longer we let this go, the longer the board is put in a legal untenable position. You guys understand
I
this, right,
do,
what I'm saying?
and I appreciate the board's time, and the reason that we brought it before the board was as the dispute resolution
I get you.
mechanism in here.
I get you. But I think, you know, this is, I hope you all are feeling the board's malleability, if that's, you know, the right word, because we don't have to be malleable, right? We don't have to be. We could have been the board in 2006 and rule right now, right? And I think you wouldn't get the votes, I think. I don't know. But I think this board, if they entertain the motion that I just put out there, will demonstrate our malleability, and hopefully you and your clients can reciprocate that respect. But I will say at next meeting, we will take up staff recommendation if there is no viable plan. At least I will.
Maybe we consider the second from next meeting just to give us sufficient time to, okay.
Sure. Ask for the third one if you want. But we better have a
Maybe the
plan.
motion is a future meeting.
Future meeting.
Because it has to get on the agenda, staff needs to
Good
go
call.
right up together.
Good call, Member Smith. Thank you.
Just give them flexibility.
So I'll amend my motion to just say future meeting. And then Scott, you okay with that?
Trevor, but yeah.
Oh.
It must be the chair. It's the chair.
Oh.
Did you make the motion? Did you get a second?
Wait, let me just recover from that blow. This is the guy I'm running, and I passed him, and now I feel real bad, Trevor. Okay.
Sorry, Chair, one question to
Yeah.
clarify. The proposal you would like to come back to the board is for minimizing the loose debris that's there. not-
Non-structural material.
Okay, non-structural material, not for what we do on the slab afterwards, because I would point out that there is currently, as recorded on title, a prohibition from using the structure. So
I'm
this is
sorry, I was reading a
condition-
note. I'm sorry, go
sorry,
ahead.
Condition 7 states that the current or future landowner shall be prohibited from utilizing the structure. So long as that's on there, we can't actually do anything with it, which I think is fine. But if the board would like for some sort of plan to be put in place to address, you know, whether it's propagating native Hawaiian species or whatnot, I think we'd have to maybe address condition 7 on that.
Well, let's just deal with the non-structural light debris. Forget about the nursery, forget about painting it green, whatever, right? Let's just deal with this first. Okay. That's good.
It
Okay.
is.
Trevor.
Yes, Coyote.
Yes. Trevor and Tiger. Are you guys good with that? I don't want to, you know, at the board level, we have to be careful of mission creep and stepping on administrative toes, and I don't want to do that. So, but I hope you agree that we're trying to find some kind of middle ground. But I think the board, we all support your recommendation and appreciate you guys' work.
Thank you.
Fair?
Yes.
Okay, motions out there?
Second. You made the motion.
Yeah, I just, yeah.
Yeah, second.
Yep. Okay, discussion? All in favor? Aye. Oppose? Okay, one opposed, the ayes have it. Passes, we'll come back at future meeting with the, as discussed.
Okay, thank you.
Thank you, thank you guys.
Thank you, guys.
We're gonna take a 5-minute break. Yep. Bye.
Finally, your turn, finally your turn.
Thank you, baby.
We'll wait for Riley to come back.
You're still my friend.
Sure.
Oh, hey, no,
You know my friend.
yeah, it's ruined about 5 minutes ago. No, I'm just kidding. Of course I'm your friend.
I may not be your friend anymore.
Yeah. Count on.
Oh, I think we've got a quorum. We can go, because Vernon has to leave by 4. Oh, here he comes. Thank you, Riley. We're back in session. Thank you very much.
Thank you, Chair.
Board Member Hune for taking. First item in this return is F1. Yep.
Aloha Chair Ching and members of the board. My name is Kathy Gawicki and I'm an aquatic biologist for Division of Aquatic Resources. And today I am presenting item F1 for DAR, which is a request for authorization and approval to issue a Papahānaumokuākea Marine National Monument Native Hawaiian Practices Permit Renewal to Palika Andrade of the Namaka Ona, formerly Namaka o Papahānaumokuākea, and the University of Hawaii at Manoa for access to state waters to use traditional ecological knowledge to conduct intertidal surveys and monitoring to advise and direct management strategies for intertidal fisheries activities. And this project is a collaboration with U.S. Fish and Wildlife Expedition. The project will conduct intertidal surveys and monitoring at Nohoa for intertidal fisheries, specifically Opihi. These surveys are a continuation of previous intertidal ecosystem studies. I think they've been doing the studies for over 12 years. And they will be looking at patterns of reproductive cycles, recruitment, and productivity. Sampling of gonads for Opihi will be done to determine fecundity at size. And the project will also collect environmental data related to traditional Native Hawaiian marine management and expand the application of traditional Hawaiian environmental monitoring tools and methodologies such as Huli'ia. And Huli'ia is an observational process documenting seasonal changes and shifts across entire landscapes, identifying dominant cycles within certain species or occurrences, such as flowering, fruiting, presence or absence of flora and fauna, cloud formation, spawning, or recruiting of fish species. And as stated above, it's a collaboration with this U.S. Fish and Wildlife Expedition. The primary goal of that expedition is to conduct terrestrial surveying and controlling of terrestrial invasive species and terrestrial native species monitoring. So therefore, the researcher will be conducting the intertidal stuff opportunistically whenever they have time to do that, you know, on the side of the terrestrial surveys. And the activities, this permitting period will be between April 2024 and April 2025. One of the expedition leaders, Palika Andrade, wasn't able to make it today. They're participating in the E'alapu conference that KUA is holding on Kauai. But I did follow up on some questions from last year. I don't know if you remember when we talked about this last year, but I think, or maybe Riley asked about the sizes of the Opihi. And so I did follow up with them. So, so there are 3 species up there on Nihoa, but they really only collect 2 of the species because the 3rd species, the Ko'ele species, is not as abundant, just naturally not as abundant there. So if they come across like a large patch, they will collect that one, but she won't collect if it looks like they're not heavily distributed. And yeah, the other 2 species, Olina Mina and Maka Iauli, they're both 2 to 4 inches are the size inches that they collect. The Ko'ele is the larger one that's 4 inches, but they don't usually collect those. And I think those were the questions that you had asked.
You heard about 2-inch Alina Lina.
Don't see those too often. I was just gonna say, no, I don't think we see. Board members, do you have any questions? Is there anybody on Zoom, anybody in the room who'd like to provide comments? Anybody on Zoom? Okay, move to approve, Chair. Thank you. Do you have a second? Okay. Motion has been moved and seconded. We're in discussion. Seeing no discussion, call for the vote. All in favor, say aye. Aye. Any opposed? Vote unanimously passes. Thank you very much.
Thank you.
All right.
Thank you. Have a good weekend.
Thank you, we will. Okay, the last item on our agenda, F2, the long awaited, and again, this is just a non-action item, but I wanted to brief the board.
Yeah, good afternoon, Chair. Good afternoon, Board. My name is Ryan O'Connell, East Hawaii Island biologist with the Division of Aquatic Resources. Today we are for an informational briefing on the draft documents of the proposal to designate the marine areas of Papahanaumokuakea Marine National Monument as a National Marine Sanctuary. Currently is a monument, so other layer of protection sanctuary pursuant of the National Marine Sanctuary Act. The marine areas encompass about 580 square miles. The National Oceanic Atmospheric Administration is proposing this action to add conservation benefits of the Natural Marine Sanctuary System to the area. The state of Hawaii, Department of Land and Natural Resources, Division of Aquatic Resources is proposing to include state waters, including the Northwestern Hawaiian Islands Marine Refuge in this action. At this point in time, I'm gonna turn it over to our legal fellow, Kellyanne, and our partner from NOAA, Eric.
Okay, so hi, I'm Kellyanne Kobayashi. I'm a legal fellow with the Division of Aquatic Resources, and I kind of help in all aspects of Papahanaumokuakea management through at DAR. And I was mainly tasked with this big project of National Marine Sanctuary designation. So we just hit a big goal. Everything got published in the beginning of the month. And Eric, did you want to introduce yourself?
Absolutely. Aloha, Chair, board members. My name is Eric Roberts. I'm NOAA's superintendent for Papahanaumokuakea Marine National Monument. Thank you for having us today.
So we have a presentation, and we didn't publish this video yet, but we wanted to share it with you folks since it got approved, or
It is an approval status today.
it's in
This is the
process.
final draft. So you're getting this is like an advanced showing of
right.
Yeah, we're hoping we can be sharing this one widely. And it's going to be a promotional video for the National Marine Sanctuary designation.
Oh, wrong already. You gotta have the
Yeah,
chair
we don't even have
in the front saying, aloha.
We may indeed do that at a public meeting, but yeah, for now.
We don't have access. Okay. I can screen share it. I just got logged out of.
It's worth the wait.
I think it's worth it.
It's worth
And
it.
we're
It's worth
last,
it.
so.
Yeah. So I'm gonna lose board member Char at about 4:15, Bernard?
4:15.
Okay, but no action, so we can stay. We can
Okay, I
stay.
don't own the video, so.
I'm signed in.
We might get out in 2 minutes.
It should.
Okay, yeah, we don't have access to the video right now.
Oh,
shucks.
I'm not the owner.
You were able to view it earlier, right?
I can view the video, but they don't have access to the video, or you don't have access to the slides or the video.
I think I don't have access to the video in the presentation, but let me see if it'll come up if I just don't put it in slideshow. So yeah, I can view the rest of the slideshow, just not the video.
Oh,
Can you turn your computer around so we can see your
Yeah.
computer?
What's
okay.
your screen now?
I'm just gonna try and log into the Zoom.
You only waited all day to present. this.
Yeah.
And we tested it twice.
Yeah, we were
just
like,
so you
it
know.
works.
We tested it
We
upstairs
were like,
twice.
this
and
is
it-
gonna
and it-
work.
And it
Oh,
worked.
We just tested on the wrong computer.
Yeah.
We need to-
Yeah.
But
Okay,
this
wait.
is really, okay. Does it work?
I'm gonna just do it from my.
Okay, yep. And we can all see from yours.
I really needed.
I just joined the Zoom meeting.
Yeah.
Okay.
I really needed this video after what you did.
So anticlimactic now.
We really wanted to show
Oh, you
this.
did?
Yeah.
Because they don't want everybody else to see it.
Oh,
yet.
yeah.
Yeah,
I
you
know.
guys are getting this.
So this is a preview of what's to come. at
Yeah.
This is an
upcoming public
advanced
meetings.
screening, we'll call
Advanced
it.
screening.
Advanced screening.
Okay.
Oh, here we go. We look like we've got something happening. Oh,
Okay, wait, where's the audio now?
uh-huh. Salvage.
Oh. I don't know about audio.
Did you optimize for sound? When you hit the share screen, there's like an option to share.
Yeah, okay, just optimize.
Oh, it works.
I'm muted.
Oh. Well worth the wait.
Yay.
You guys hiring on?
Good. Yeah, so that was our video. Okay.
What
Good
species
job.
is the rectangle?
That's beautiful.
Yeah, I don't know how to get rid of that. It's not on my computer, so
Yeah, it isn't there.
it's weird.
I think it's on
Great
this.
job.
Nice.
That's awesome.
Yeah.
That's all, you don't need any words.
Okay.
No,
Just-
Could
gotta
you
open 'em
share
up, though.
the rest? Thank you. I had my notes.
It's so soothing, yeah.
Oh my God, that's, yeah.
I think I was gonna start off, right?
Yeah.
Okay, if you can go to the next slide, please, and then I'll. All right, well, I'm glad we got that to play. That
Yes,
was
yes,
kind
a
of
good way to start.
the highlight. So, being respectful of time, we'll go ahead and go through this, and we'll provide you an overview of the sanctuary designation process. We'll provide you an overview of what the proposal is for Papahanaumokuakea, overview of the draft regulations, the draft management plan, and the draft environmental impact statement. And then after that, we'd obviously be open for any questions you may have. Next slide, please. Okay, so you're seeing here is an overview of our National Marine Sanctuary system. As you're likely aware, the National Marine Sanctuaries are federally designated areas within the United States waters to protect areas of marine environment with special conservation, recreation, ecological, historical, cultural, archaeological, scientific, educational, or aesthetic qualities. As this map represents, the Office of National Marine Sanctuaries serves as the trustee for a network of underwater parks encompassing more than 600,000 square miles of marine and Great Lakes waters from Washington State to the Florida Keys and from Lake Huron to American Samoa. The network includes a system of 15 national marine sanctuaries and 2 national marine national monuments, Papahanaumokuakea and Rose Atoll in American Samoa. Next slide, please. National Marine Sanctuaries carries out diverse programs for each of its sanctuaries and monuments as appropriate. With this, we help protect endangered species. We focus on indigenous community engagement in maritime and cultural heritage. We conduct research and monitoring for unique and newly discovered habitats and species. We focus on local education programs and outreach to local and international audiences. We establish and work with advisory councils and volunteer programs that also involve citizen science. We prioritize community partnerships, and it's critical for our place-based management focus. And we also promote recreation and tourism in support of local economies if that is desired and appropriate, as we recognize that one size does not fit all, and each sanctuary is intended to be place-based and informed by the place, the resources, and its communities. Next slide, please. So I also wanted to highlight just a bit on the differences between a marine national monument and a national marine sanctuary, because that is a question that comes up often. First off, they're created under different federal laws. A marine national monument is designated by a presidential proclamation under the Antiquities Act. And national marine sanctuaries are designated primarily in 2 ways. Under the National Marine Sanctuaries Act through either an administrative action by NOAA or through legislative action by Congress. Consistent with our current action, the current administrative action is a highly public process with multiple opportunities for public engagement. In terms of national marine sanctuaries and marine national monuments, they are also managed very differently. National marine sanctuaries are managed by NOAA through its Office of National Marine Sanctuaries, and in many cases, such as Papahanaumokuakea, would be in partnership with state government. We manage these special places in a way that integrates local governments, communities, and indigenous knowledge. Marine national monuments are typically managed by multiple government agencies, which may include NOAA, the Department of Interior, and other federal and state partners. Specific management partnerships vary depending on the details of the management arrangement established in the presidential proclamation. For example, Papahanaumokuakea Marine National Monument is co-managed by the Department of Commerce through NOAA, the Department of Interior through through Fish and Wildlife Service, the Office of Hawaiian Affairs, and the Hawaii Department of Land and Natural Resources. Sanctuary designation would provide added protection to an area already managed as a marine national monument by augmenting and strengthening existing protections for Papahanaumokuakea ecosystems, living resources, and cultural and maritime heritage resources through the addition of sanctuary regulations. The National Marine Sanctuaries Act would enhance resource protection, increase regulatory compliance, ensure enforceability of protections, provide natural resource damage assessment authorities, provide for interagency consultation, and expand the opportunities to conduct research and monitoring and education and interpretation for the public on the significance of this area. Sanctuary designation would also create a sanctuary advisory council that it could advise NOAA and the state of Hawaii on management and represent relevant interested parties. Additionally, friends groups and chapters of the National Marine Sanctuaries Foundation can act as community partners, and thousands of volunteers dedicate themselves to citizen science, monitoring, outreach, and education programs through these friends groups. Sanctuary designation impacts a specific set of new benefits afforded by the NMSA as well, the National Marine Sanctuaries Act, which allows ONMS, Office of National Marine Sanctuaries, to supplement existing authorities in part through emergency regulations when necessary to prevent or minimize the destruction of, loss of, or injury to a sanctuary resource, as well as penalties where any violations of the National Marine Sanctuaries Act or regulations or a permit issued thereto is subject to a civil penalty. Additionally, response costs and damages from any person who destroys, causes the loss of, or injures a sanctuary resource could be pursued through sanctuary designation. Next slide, please. So just to give you a little bit of history on kind of where we're at now, this effort to designate Papahanaumokuakea as a national marine sanctuary dates back at least 2 decades, starting as far back as 2000 when President Clinton created the Northwestern Hawaiian Islands Coral Reef Ecosystem Reserve and directed NOAA to consider designating the area as a national marine sanctuary. In 2016, when President Obama created the Monument Expansion Area, extending protection out to 200 nautical miles, he also asked NOAA to consider designating the Marine National Monument as a national marine sanctuary. More recently, Congress directed NOAA to begin the designation process in 2020. In 2021, we published our notice of intent and hosted public scoping meetings throughout December of 2021 and January of 2022. And on February 29th of this year, we released our draft designation documents in coordination with DAR in the state of Hawaii. Next slide, please. This shows you where we are in terms of the overall process. We're now in stage 3, which is, stage 2, which is releasing the draft documents. The public comment period opened on March 1st, and that will stay open through March 7th. The next step, which you don't see here, would be the review of any public comments, and then NOAA would make a final determination on whether a sanctuary would be appropriate for Papahanaumokuakea. If they decide that it is appropriate, then we would move forward with creating final documents for the EIS, as well as the management plan and the rulemaking package. And then we would release those to the public once more. And that would also trigger the allowance for both Congress and the governor to review.
And Eric, it's to May 7th.
May 7th, yeah. So it's a 68-day public comment period to more appropriately line up with the state process for HEPA as well.
Okay, thanks.
Next slide, please. So I'm just going to briefly go over the alternatives that are in addition to the no action alternative. So we have 3 that are primarily boundary alternatives. The regulations would remain the same across all 3 boundary alternatives that I present to you today. Alternative 1 is our agency's preferred alternative, and that is coextensive with the marine portions of the monument and the monument expansion area. So that includes that outer boundary of the MEA, the monument expansion area. It provides the most protections to the most vulnerable areas of Papahanaumokuakea, including shallow reef waters threatened by the impacts of climate change, marine debris, invasive species, and international traffic. It provides protections for open ocean and deep water resources of the expansion area, including seamounts, supporting rare oasis of life in this primary pelagic and deep ocean environment, and maritime heritage resources from the Battle of Midway. It also ensures protection for areas that are ecologically connected. Next
Does
slide.
it also include the Pacific remote islands?
No, ma'am. This is strictly for the Northwestern Hawaiian Islands. Next slide, please. Alternative 2, as you see here, includes the waters of the original Papahanaumokuakea Marine National Monument, which is essentially from 0 out to 50 miles from shore. This would protect a total of 139,000 square miles. It would ensure protection for the areas that are essential habitats for rare and endangered species. And then how this would play out in terms of a regulatory approach would be that sanctuary regulations would apply from 0 to 50 nautical miles, And then the proclamation 9478, which expanded the monument, would apply from 50 to 200 nautical miles. Next slide, please. And then our third boundary alternative would include all the waters of alternative 1, except for Midway Atoll and the Hawaiian Islands National Wildlife Refuge waters, which are managed by the U.S. Fish and Wildlife Service. So this would protect in total 581,000 square miles. I will also note that there are state waters overlapping the Hawaiian Islands National Wildlife Refuge. Excluded areas will continue to be managed as a monument.
So is the only excluded area in this alternative 3, is it just Midway?
Midway and the Hawaiian Islands National Wildlife Refuge waters.
And that overlaps with the state of Hawaii Marine Refuge, Northwestern Hawaiian Islands Marine Refuge. In some places.
Next slide, please. Okay, so just to kind of summarize what the proposed sanctuary would do, and then following what it would not do. So it would add the conservation benefits of the National Marine Sanctuary by bringing in the National Marine Sanctuaries Act protections and authorities into Papahanaumokuakea. It would make minor changes from the existing monument regulations to remove discrepancies and gaps and prohibitions between what is now Papahanaumokuakea Marine National Monument and the monument expansion area. And I'll elaborate a little bit more on those in following slides. And it would allow for permitting of sustenance fishing across both zones. Right now, that is only permittable in the original monument area. And it would exempt non-commercial fishing that is permitted by NOAA Fisheries in the monument expansion area. Next slide, please. What the proposal would not do is it would not remove the area's status as a marine national monument. It would not reduce the protections already provided by the monument. It would not supplant the authority of monument co-managers, including the state of Hawaii through the Department of Land and Natural Resources, as well as the Office of Hawaiian Affairs. It would not change the prohibitions on commercial fishing, which would remain prohibited. It would not prohibit non-commercial fishing, which would be permittable under the National Marine Fisheries Service. And it would not change any Native Hawaiian practices permitting activities up there as is currently occurring under the monument structure. Next slide, please. So this is just a quick capture of things that would be prohibited and then things that could be permitted. In terms of strict prohibitions, it would be commercial fishing, it would be oil, gas, mineral, and or energy development, any use of poisons, electrical charges, or explosives, any release of introduced species, to the deserting of a vessel or anchoring on any live or dead coral. Activities that could be permitted would be non-commercial fishing, as I previously mentioned, disturbance to submerged lands, disturbance and or removal of any living or non-living sanctuary resource, attracting any living sanctuary resource, touching coral, living or dead, swimming, snorkeling, or scuba, discharging or depositing any material or other matter into a sanctuary, and anchoring a vessel. So this list on your right would be available to be permitted if other conditions were met. Next slide, please. So just to provide additional clarification, all proposed sanctuary prohibited and regulated activities are currently in place for the original monument area. That's in the 0 to 50 nautical miles. Compared to the original area, only 2 differences are proposed. One is exploring for developing or producing oil and gas or minerals in the original area. Right now, that is prohibited in the monument expansion area under the presidential proclamation, but it wasn't prohibited in the proclamation that formed the original boundary. So we would bring this so it'd be consistent across the entire sanctuary. So again, these are both prohibited in MAA, but not in the original area. The other one is deserting of a vessel. In the expansion area, you cannot desert a vessel. In the original area, you could only desert a vessel by permit. And so we would be prohibiting that across both areas for consistency.
What does that mean? Who would
Yeah, we always thought, like, why would we want to even have that ability to have it deserted up there? But I think it just wasn't addressed in the original proclamation. Next slide, please. Okay, additionally, there are items as listed here that are regulated within the original area, 0 to 50. And I apologize if I'm confusing going back and forth, but It is confusing, and that's why we're trying to make some uniformity with the sanctuary proposal. But these are areas that currently could be regulated in the original boundary, but cannot be regulated in the MEA. So we would be, again, bringing these in so there'd be consistency across the entire sanctuary designated area. And that would include attracting any living sanctuary resource, touching coral, living or dead, swimming, snorkeling, or closed or open scuba diving, discharging or depositing materials, and anchoring a vessel. So again, this would make it a permittable activity after review. Next slide, please. And this is my last slide before Kellyanne takes over. So you'll have a break after this, from me at least. So consistent with the existing proclamations, there are some exemptions that we would just be carrying forward as the president intended, and that would be these would be exempt from permitting, and it would be activities necessary to respond to emergencies that threaten life, property, or the environment. It'd be activities necessary for law enforcement purposes, activities and exercises of the U.S. Armed Forces, including those carried out by the U.S. Coast Guard, scientific exploration or research activities by the Secretary, by or for the Secretary of Commerce or the Secretary of Interior in the outer sanctuary zone, which is the monument expansion area, and non-commercial fishing in the outer sanctuary zone that is authorized by Magnuson-Stevens Fisheries Conservation and Management Act through NOAA Fisheries, provided that no sale of harvested fish occurs. So I will say next slide now, and I'll turn it over to Kellyanne.
Okay, so what is also included in our published documents is a draft sanctuary management plan. So basically, the management plan is a document that will describe the goals and priorities used in management for the area. It's organized into these pillars of management. So for Ho'omana, it's ensuring long-term viability and resilience of Papahanaumokuakea. Things would include research protection efforts, permitting, enforcement, are kind of outlined under this category. For Ho'ike, it would be supporting, conducting, and coordinating research and monitoring, including multiple forms of knowledge. So that's things like ecosystem monitoring, cultural research programs, maritime heritage research, and others. For Ho'okui, providing necessary policy, programs, and structure to ensure effective integrated management. This includes operations planning, cooperative co-management, and also part of permitting would fall under this category. For Ho'olu, pursuing, building, and maintaining meaningful partnerships to strengthen conservation efforts and community engagement. This is going to be a big part of the Sanctuary Advisory Council, partnerships with academia and other partnerships. For Ho'olaha, inspiring current and future generations to care for Papahanaumokuakea through outreach, partnerships, and career pathways. The plan's framework was developed in coordination with the co-managers, and the future monument management plan, which will be like a heftier document, will incorporate this document and any other management plans that the other co-managing agencies have. And this document is informed by the recent co-management document that came out, Mai Kapomai, which is a Native Hawaiian guidance document. And we hope to continue working on our management plan after this. And next slide. So the management plan is actually an appendix to the draft environmental impact statement. So the draft environmental impact statement is for the proposed action, which is the designation of a national marine sanctuary in the marine waters of Papahanaumokuakea Marine National Monument. And the draft environmental impact statement analyzes the impacts on the environment of the proposed action, including the 3 alternatives and the no action alternative. It serves as a resource assessment that details the present and potential future management of the areas, but it's not like exclusive. So other management activities that fall outside of the EIS will, of course, go through their own environmental review processes. This EIS mainly evaluates how the implementation of the proposed boundaries, regulation, and management plan would affect the environment. The monument and its regulations will continue to remain in place. And the idea is that the new proposed regulations would be at least as protective as the current regulations. management of the sanctuary will not change the current co-management structure of the monument. And long-term beneficial impacts are anticipated, and we did not find significant adverse impacts under any of the alternatives. We also included, next slide. We also included a cultural impact assessment, which was conducted through contract with Noho Papa Hawaii. And it includes a legal analysis that will support a Kapa'akai analysis if that's made at a later time. And Noho Papa interviewed 25 individuals, highlighted some recommendations from these participants. And these recommendations and considerations were included and incorporated during our drafting of the environmental impact statement, the draft environmental impact statement. Next slide. So this is kind of like for that number 4 option, which Eric touched on earlier. So after the public review, we will gather all of the input and make the final decision on moving forward. If we decide to move forward, next slide. We will revise our documents as needed based on our feedback. We have to attain the CZMA federal consistency determination still. And before the designation does become effective, the governor will have an opportunity to review all the documents as well as Congress before any decisions are made, which will be after the final documents are drafted and published. Next slide. Okay, so after pretty much within the coming weeks, we're going to get really busy starting to do public comment meetings. So this is one of the earliest meetings we're having. After that, on Monday, the state is hosting an online virtual informational meeting. That one will just be this, pretty much this exact presentation, but we're going to have time for people to ask questions if they didn't understand something. And that way it'll help them inform their public comment. And then we have these public comment meetings scheduled in April. And we would love if you or anyone wants to come to any of these meetings. We are actually in the process to finalize an additional meeting for Kauai, which will be on the 13th. It just really worked out well for us because we have to come back that day anyway. So we're going to add an extra meeting in Lihue. So it's not on here. And we will be advertising that in the coming weeks. And next slide. So the electronic comments, you can submit them as of the beginning of the month. You can actually submit them online. If you go to regulations.gov and you go to this docket number, it's a little weird. You have to actually go to the proposed rule in order to comment. It doesn't just pop up automatically, but you can always reach out to us if you have any questions or trouble with that. Next slide. And then written comments can be mailed to Papahanaumokuakea's office, not the DAR office. Don't mail it to the DAR office. Please do not mail it to the DAR office, and don't mail it to the board. Please mail it to the Papahanaumokuakea Marine National Monument office on Ford Island. And then also you can like take a picture, I think, and if you want to like scan it and upload it too, you can upload things on the website. Next slide. And that's the end. So we have our QR code here to the website, and you can also submit and our link to the docket where you can submit comments.
Thank you very much. I do have a disclosure. I actually helped to facilitate several of the public meetings after the public notice was published. So I have a little bit of history with
Maybe
it.
we could bring you back for this next one.
Yeah, if you want to be our facilitator.
All 9 of them.
Yeah. I will be at least 2 of them. Yes. But it is nice to see you. Thank you. I am extremely pleased to see that you are here at this point. So, board members, questions? This is just informational.
Couple comments.
Yeah.
One, fantastic, great job, love the video. When you go out for advertising for public meetings in April, have you reached out to OHA to publish in Kawaiola?
Yes.
Fantastic. Okay, good.
We've done a whole, just so you know, we worked with them to do a whole year-long series on Papahanaumokuakea that kind of talked about the place and the Native Hawaiian connection to this place.
Good.
And it's going to end with kind of a call to action advertisement of the public meetings.
Awesome. And then just, I don't know if, I'm not too bright sometimes when it comes to English language. But, if this is going out to public, double negatives, or in my case, triple negatives sometimes confuse me. Prohibitions that cannot be permitted, kind of, that language is a little shaky for me, so I have to read and reread, and I was like, what did you say? No Hawaiian fishing? So just a note on that, maybe simplify, because the audience might be a little different, right? If you're not bright like me, then I won't understand clearly what you're saying on the slides.
Fair enough. No.
Very good point.
And then last one, there is a permitted use of the armed forces, I think, vis-a-vis the Coast Guard. Is that in one of the slides? I didn't want to interrupt you guys what happens, how can I say this lightly? What happens when administration changes, or if it changes and DOD or armed forces have to do whatever they do? Does the sanctuary protect the resource?
What's interesting right now is if you look at
and I meant federal administration, not local.
Right.
Okay.
Yeah, if you look at the current presidential proclamations, they do carve out exemptions for any armed forces activities, which includes the Coast Guard. And there's always that and includes the Coast Guard, because the Coast Guard's not under Department of Defense. And so it creates this unique, do they mean both all armed forces or not? So right now there is no requirement for any federal agencies, including the military agencies, to consult with any of the co-managers on activities. They just have a strict exemption based on the presidential proclamations. What the Sanctuaries Act brings to the table is a requirement for any federal agency to consult with the Office of National Marine Sanctuaries, that is NOAA, if there's an expectation that their activity could harm sanctuary resources. So that would bring in an additional step that could consider potential impacts to sanctuary resources that does not exist under the monument framework.
I'm just concerned that the president now or the one in the next cycle are very fundamentally different.
Right.
And so the president, to be clear, still has the power to exact what he or she wants.
Not under the Sanctuaries Act. Under the presidential proclamations and executive orders, they do. So those could be rescinded, and that's been there's challenges on the East Coast around that. But under the Sanctuaries Act, it would take either an act of Congress, or we'd have to go back through the public process to change ultimately what a sanctuary designation would become.
Okay, maybe up to you guys, but maybe want to have a slide on that, because I get a little nervous.
No, you're out. And that to me, for me, that was one of the major differences.
Yeah.
It is the certainty and assurances. Currently under the monument, a president can change that at any time. And I think there was an attempt by President Trump to, well, I'm saying that. And so there is, so this sanctuary, so that's why there is this aggressive motivation to get this sanctuary designation before the change of administration, just for purposes,
Just in case,
but your comment is well taken, yes.
And then if I may, Chair, also just on your point about public comments. So the one thing we didn't say, and we should have made that clear, is that like when we put out our notice of intent, and we had our public scoping meetings, we will also receive comments in both Olelo, Hawaii and English. And to our knowledge, this is only the second time that it has only been offered in kind of a federal process.
Awesome.
And so we're really proud that we continue to provide that opportunity.
Awesome, thank you.
Yeah, and that was a really important as part of this, that we did that. I will say, if you recall Westpac, because there was an attempt by Westpac had the authority to draft some initial rules that would impact the monument, and but NOAA had the authority to ultimately decide on those regulations. Is that correct?
Yes, Chair. So under the National Marine Sanctuaries Act, it affords the Fisheries Council the opportunity to propose draft fishing regulations for any national marine sanctuary. So Westpac did provide a proposed action that now lies. Well, we concluded that process. We essentially accepted everything except for the inclusion of self-harvested resources. So that proposal now rests with the National Marine Fisheries Service, and so it's their responsibility now
NIMS,
to.
Not NOAA.
It's
NIMS.
NIMS that would now implement those regulations. Those have not gone out.
I
Draft
see.
regulations have not gone out for public review yet, but that is a process that's underway by the National Marine Fisheries
And that was
Service.
the one that specifically about the definition of sale or.
Yeah.
Yeah.
Customary exchange.
Yeah.
customary
Yes,
exchange.
ma'am.
But NIMS is part of NOAA.
Yes.
And they will be at our public comment meetings.
They will.
Okay.
Yeah.
Okay.
Yes.
So
Alright.
also there to help answer questions.
Board members, any other questions or comments? Yeah.
Can you send us a copy of that video?
As soon as it's
Approved.
approved, absolutely.
Yeah.
Yes.
Yeah, yeah.
Who has to approve it?
Just our headquarters,
Oh.
but it's,
Like in DC.
the final draft came out today. We're just waiting for our headquarters
Mhm.
office
It's
to
their
approve it.
lawyers.
We've been working on it for a while.
Yeah, we've been working, but absolutely, as soon as I get the thumbs up, I will let Ryan and Kellyanne know, they can share it with
Not
the
approve
board.
that video, right? You'll be out of your mind.
You would not believe
Yeah,
the
yeah.
the scrutiny that all of these documents that go through.
And like
Okay.
really small changes every time.
Yeah, it's mainly the
It's the
wording.
wording, yeah.
Yeah.
that's just the wording. Yeah. Okay, thank you so
Thank
very
you.
much for the
Thank you.
presentation.
Yes.
Thank you.
And appreciate where you guys are. I mean, it's been a long journey, long journey.
Follow Chair.
Thank
very
you.
Thank you, board
Okay.
members.
Have a good day, you guys.
All right, with that being said, I think there's no other business before the board. I'm gonna declare the meeting adjourned.
Thank you.